application, my lord, contempt application.
For upgradation under section 10 of the West Bengal Highway.
But I mentioned one matter, my lord. It is given for hearing by the in the monthly list. Monthly item number 1200. Page number 1016. But entry order will expire on the 30th.
Will expire on 30th.
On 30th.
Give the number.
My
Extension of interim order.
My lord, I beg to mention one matter for extension of interim order, my lord.
Give the number, please. To be mentioned, extension of interim order.
Sir, may I be permitted to mention one matter for upgradation, my lord? Appearing item number 896, it relates to termination of my mining lease. Now, I've been served with a purported notice during pendency of the litigation that action will be taken under the Public Demand Recovery Act since the amount of bid amount due, certain amount. Now, I prefer this application challenging the termination notice.
Give the number.
My lord, may I be permitted to mention, my lord, the matter is running, my lord, daily lease. Land matter hearing. My lord, after mentioning your lordship daily. Yes, all complete, my lord, my learned advocate, senior advocate, my lord, Chondi Charan, they each, my lord, very short matter, my lord.
Number, please.
Yes, my lord, my lord, kindly take this matter, my lord, tomorrow top, my lord.
Tomorrow top, I do not know. Give the number.
My lord, during 1.5 months, we are waiting for daily list. Item number 5, item number 6, item number 7.
The daily list. Give the number.
It was daily list, my lord.
Yes.
But upgradation, my lord, yesterday, my lord, the same matter disposed of on 2 matters, identical matters, my lord.
Lordship, may I be permitted to mention one matter? Lordship, I am mentioning this matter for inclusion under the heading of to be mentioned. Lordship, on earlier date, 5th April 2023, Lordship was pleased to pass an order, but Lordship, one typographical mistake was occurred.
Asking for a correction.
Lordship.
Give the number. Correction. To be mentioned, correction.
My lord, I am praying leave to file an application, my lord, move for the extreme urgency, the railway authority, they are the licensed petitioners. Railway authority issued a notice on 24th to evict the petitioners by 30th. So I am paying leave, my lord, to move it on.
No, leave is a file and come back. Please file, give the number, I'll include it.
I'll
Leave is not necessary.
I'll give
File
the
and
There were 48 hours a day after tomorrow, my lord, at the top.
Please file and come.
Well, Lordship, kindly to mention one motion, Lordship. Due to the lack of determination, it was released from the court room number 19, Lordship.
Where you can give the numbers to be included. Yes, call the days list, please.
Item number 1. But I am for the petition. Actually, this is the unauthorized construction of a road by the Jila Parishad without acquisition of our land.
Is it appearing for the first time?
No, my lord, it is not appearing first time. I want to, my lord, dispose of the main matter. They have undertaken. They will not construct any road during the pendency of the writ petition. But they have already completed the road. Therefore, my lord, I want to, my lord, that the main petition be disposed of. At any day, you will see fixed it. Without acquisition of land, a road have been.
This is a contempt application.
Contempt application. Lord, contempt application they have undertaken when it was moved.
Have you served the contempt application?
Yes, Lord, I have served the contempt application. It was taken up hearing once.
Where is your affidavit of service? Where is your affidavit of service?
Second it over for it.
And which order are you challenging?
But order challenging the order dated
17th December 2019.
17 December 29.
It's not my order.
No, this is the order of Honorable Justice Original Sina.
Yes, but there is another bench who is dealing with contempt applications. Please appear before that bench.
But I have seen there is another bench.
Yes.
Your Lordship has also.
So I do not have determination.
And I do not want to place this.
Our separate
Contempt.
bench is dealing with it. I cannot do anything about it, sir. I have to release the matter. The matter is released due to lack of determination. Okay. Next.
Number 2. But I appear for the respondent Board of Trustees.
Lordship, I appear for the petitioner. This matter has earlier come up for restoration, wherein my learned friend had pointed out that a section 5 would be necessary. My lord,
Yes.
that a section 5 would be necessitated.
There's a delay.
Yes, my lord.
So you're asking for some time?
No, my lord. I have filed my section. Yes, my lord. Section 5 has been filed along with my restoration.
Have you received a copy?
Yes.
So let this be allowed.
Yes. As I submitted, my lord, I don't oppose.
Can we deal with the petition?
My lord,
Not today, lordship. I am led by Mr. Rudraman Bhattacharya. So if the matter could be
I am
fixed-
also being led by Mr. Kishore Datto, learned senior.
Some time.
My lord, couple of days time. My lord, only one prayer, my lord. Prior to your lordship start dictating, my lord, only one sufficient. Since I am appearing for an statutory authority, kindly add, if possible, one line that I have formally opposed the restoration. That's all.
So where is the section 5 application?
My lord, I have it's filed, my lord. Can two.
Can two. Liste আছে. Liste দেখুন can 1, can 2 দুটোই আছে.
When did you file it?
My lord, it's been filed on. It was filed on last Thursday, lordship. On 20th April, lordship, last Thursday, lordship.
Has it come?
কুড়িটা।
Allow করবেন, Mr. Rudraman Bhattacharya.
Let me just find it. Can 1 or can 2 actually. Or learned counsels for the parties. Paragraph learned counsel for the respondents raises objection to the applications. Paragraph. Paragraph. Good grounds being made out by the petitioner for his non-appearance before the court on the relevant date, comma. The restoration application is allowed. Paragraph, the order passed on 9 November 2022 is set aside. Paragraph, the writ petition will restore to its original file and number. Paragraph, can 1 and of 2023 and can 2 of 2023 are disposed of. Paragraph, WPFA order.
Would it be your lordship's pleasure?
Yes.
I'm sorry, my lord. Would it be your lordship's pleasure to take the writ petition anytime soon, my lord? But it is covered by your lordship's decision, my lord.
Immediately after vacation,
My lord.
let the matter appear under the heading Group 1 motion on 7 June.
7 June. As your lordship please.
Great.
I'm deeply obliged, my lord. 7th June.
Item number 3, Your Lordship, I am appearing for the petitioner. My lord, I am instructed by the client that he is not willing to proceed further with this matter.
Have instructions?
Yes, Your Lordship.
Very good. Learned counsel for the petitioner submits that she has instructions not to proceed with the matter any further. Paragraph written instructions submitted on behalf of the petitioner is taken on record. Paragraph in view of the above, the writ petition being WPS such and such is dismissed for non-prosecution. Paragraph, there shall however be no order as to costs. Urgent certified. Instructions recording.
Item number 4,
Instructions.
Namgulo. Instruction. Namgulo.
Yes, next matter.
My lord, I'm for the petitioner, ma'am. My lord, this is a case of, my lord, may I tender the affidavit of service?
The respondents.
My lord, so far as this case is concerned,
Yes.
it's an Adivasi, a scheduled tribe. And naturally, Adivasis hold forest land for their own purpose, my lord. He held a land from his grandfather, then father, and then himself. And thereafter, suddenly he found that the land is not there anymore because there are constructions and other things done by the government, whatever it is, my lord. So he files under the Right to Information Act an application stating that this is my plot of land because I have my father's name also in this revenue settlement of records, and everything is with there. Kindly tells me what is the actual position. They reply after two such communications. They reply that on a part of the land we cannot ascertain your land, the acquisition officer, and he says that on a part of the land there is a forest building now constructed. So then we asked how much is the building's area and other things, my lord. That is not replied to. In the meantime, your lordship knows that a forest land held by a scheduled tribe cannot be taken away just for the asking. No notices were given. And this is very special because tribes are protected. Tribes are protected, my lord. It has to be the Gram Sabha. The Gram Sabha will take a decision and then they will go. There are many tiers, my lord, one after the other. Nothing is done. And till date, my lord, that land is within them. And I do not even know what is my land and how it has been acquisition. Now, what they try to say is they had filed an affidavit on, that on the earlier occasion, I believe, they had given a report on affidavit where they say, kindly sees that the forest officer would be the concerned officer. I take your lordship through this particular report in the form of affidavit filed by the special acquisition officer. Your lordship sees, my lord.
Have you filed an affidavit in this matter, a report? Yes? No, I do not find any affidavit on
My
record.
lord, I can hand up my affidavit, my copy.
Come on record.
Yes, absolutely. Absolutely, my lord.
So that I can. Let her come. Let her come.
We'll kindly fix the date, my lord. Very poor people, my lord, marginalized, my lord.
On prayer of the state respondents, the matter is adjourned. The matter is adjourned. Let the matter appear under the same heading on 12th May.
What, as it commenced to your lordship, my lord. And let it retain its position, my lord. I am grateful.
Item number 5.
I'm seeking a week's accommodation to file exception to the report which was filed on the last occasion, my lord.
Will you come back after vacation?
Lordship, kindly, before vacation, lordship, 1 week's time, lordship,
After vacation.
before vacation, my lord. 1 day before vacation, my lord. Any day, any day in this first or second week of May, my lord.
There is no imminent danger, so.
The danger is there, my lord. They are trying to build on my land, which has been, I'm saying that the acquisition has lapsed.
On prayer of the petitioner, the matter is adjourned. Let the matter appear under the same heading on 11th May.
Lordship. Grateful, my lord.
Item number 6.
6, my lord, I am for the petitioner, my lord. Petition.
Yes, who is appearing for the state?
My lord, on the last occasion, Joey Maith is appearing for the state, my lord, on 27th March, my lord, taking the last, and she is taking time for, my lord, the instruction.
You filed a supplementary affidavit in this one.
Yes, yes, they I also filed supplementary, my lord.
I do not find her.
This is the matter related to, my lord. The petitioner is a private limited company, my lord, the Kolani Pharmaceuticals. In the 1981, my lord, the petition, the government of West Bengal, my lord, give a 990 years lease to the company, my lord, for constructing a pharmaceuticals company. And my lord, the petitioner constructed a building, my lord, and starting a construction company, but my lord, pharmaceuticals company, but my lord, due to the pollution control board did not give any permission at that time. From my lord 1981 2005 petitioner and the company tried several occasions to get permission from the pharmaceutical company. So my lord, they are not getting. Thereafter, my lord, the petitioner placed a application before the concerned government for a agro company, my lord, rice mill. But from 2005 2009 the government is not giving any permission of the agro company. Suddenly, my lord, in 2009 the company says that as per the lease agreement, we are taking back reposition into your land. We are filing, moving a writ application before this court, my lord. In 2010, my lord, we're getting an order of the status quo. In 2013, 2011, my lord, the new government has been come. In 2000, after that, my lord, the directorship of the company also changed. The company make a fresh proposal before the government, my lord. The estate officer of the said Kolani, my lord, the urban development group, says the matter is pending before the Honorable High Court. So there is a status quo in the status quo, and we cannot go proceed because the matter is pending. So my lord, we make the company make a proposal before the government and also non-prosecute the matter because for the new further application. After 1 year, they are taking time, my lord. In 2017, the estate manager again said that the no case is pending before the Honorable High Court. So we are again proceed to your reposition your land. So we make another application. In the meantime, my lord, the urban development company and urban development and my lord, the municipal group, both are merged. And the municipal, my lord, after the filing of this writ application, my lord, I am filing a supplementary affidavit, where my lord, the municipal affairs and urban development are now merged with the same, my lord, department. And the municipal affairs, my lord, taking the money for water and they are giving trade license and everything. Now, but still the said notice of 2009 is still subsisting, my lord. And petitioner is already constructing there, my lord, their water connection is there. They are taking more than 50,000 per month, my lord, they are charging. But the said notice is still subsisting. We are setting aside before your lordship to setting aside the notice of 2009, again, which is order for 2007, they are giving. I am just, my lord, placing the 2017 notice, my lord, first.
Will you come back next week? Will you inform
My-
the state and come back? Because
my-
the state needs to respond to this.
My lord,
Please inform learned counsel.
my.
None appears for the respondents. Let the matter appear under the same heading. On 4th May,
My lord.
4th May, paragraph, the petitioners are directed to serve notice upon the respondents / learned counsel, intimating the adjourned date.
My. Duly, your lordship.
Item number
7, my lord, I am appearing for the petitioner, my lord.
7. Yes.
In terms of the earlier order, first on,
Sir,
yes, my lord, I have served. I am submitting the affidavit of service, my lord.
there's an application pending,
Yes, my lord.
substitution,
Substitution application.
only state respondents.
Only respondent, my lord, competent authority.
Municipality is also there.
Yes, my lord.
Indian Corporation,
My lord, is it necessary for making Union of India as a party in this proceeding, my lord? As the respondent did not respond in this matter.
Served upon both of them.
Yes, my lord. I have served everything. On earlier occasion, I had served.
Confirmed. Yes. Your substitution application is within time?
No, my lord. I did not file the substitution application within the time by law. A very much delay, my lord.
So you have to file an application for condemnation.
Yes, my lord.
If you abide by order 22,
Yes, 22, rule 3,
so
A,
it has
one.
abated.
Yes,
It has abated by now, isn't it?
yes, my lord. Very debatable, my lord. My client did not inform me about the death of his father, my lord, in time. Very complicated, my lord.
Your client still wants to proceed with the matter.
Yes, my lord.
It's an old matter.
My lord?
It's an old matter.
Yes.
Since the state is not a party, I cannot request anyone to appear also in this matter.
Yes, my lord.
And earlier also, I do not find anyone representing the respondents.
No, my lord. Well, it is necessary for making party Union of India.
So please do that and come back in that.
Yes, my lord.
I'll grant you liberty.
Yes. Otherwise, matter will not be solved, my lord.
Affidavit of service. None appears for the respondents despite service. Paragraph on prayer of the petitioner. Liberty is granted to implead the Union of India as respondent number 3 in the writ petition. Paragraph, the cause title of the writ petition be amended accordingly. Paragraph, the petitioner is directed to serve copy of the writ petition along with annexure thereto upon the added respondent and file affidavit of service on the agreement date. After vacation.
Yes, my lord. After
Paragraph, let the matter appear under the same heading on 19th June.
yes, my lord. My lord, in the meantime, shall I make any application for condonation of delay in respect of substitution of?
Application so that it appears on the next day.
Yes. Grateful, my lord.
Copy to the respondents.
Yes, grateful, my lord.
Item number 8.
May I please, your lordship, my lord, I am for the petitioner. My lord, I need some further time, my lord, to file my reply.
My lord, this is the case, my lord. Order has been passed under section 50 of the West Bengal Land Reforms Act. And the petitioner has to approach before
It's with regard to accusation. It's with regard to accusations of land.
My lord,
My lord, let it appear, my lord, in the monthly list of June. We'll come up with the reply.
my lord, kindly. But we being the
It's a
respondent
forceful
number 7,
accusation, your lordship.
being the
Forcefully, my
respondent
land,
number 7, file a report in the form of an affidavit
my land has been forcefully.
saying that the
accused.
deed my landness is annexed is false.
Yes.
It is not registered.
It's a
before-
more than 30 years old document.
as
It's
the
a
report
registered
of the
document.
register.
What is the authority of the officer who has to certify that such document that as a false document? I do not.
You're challenging the genuineness of a deed. You have
Yes.
to approach the appropriate forum. The report will not.
No, that we have
It's
not
not.
challenged.
They have staged. They have
By
raised the
this
question.
proceedings, it has
They
came
have
to
raised the
us
question.
by the report of the district register saying that the deed is not registered before the.
You are appearing for?
I am for the WBSCDCL authority being the respondent number 7. If you are not,
Taken steps with regard to that?
but we have already, the land was acquired and handed over to us and
And
we have already utilized.
They
the
had
land for
taken
that.
possession, forceful
Now,
possession of my land.
Now, my lord, page 34 of the writ petition. Much prior. আমরা কি step? This is a proceeding under section 50 of the Land Reforms Act started at page 30.
challenged.
That has not been
That
challenged.
is not the subject matter out here.
The writ-
It is a forceful accusation.
This is also not the subject matter of the writ
Well, kindly see the, what is the prayer in the writ petition?
return of property. Yes.
Yes.
So that is acquisition.
Commanding the to
Accusation.
recall, cancel, withdraw the order passed in respect of the land in question. That is vague. What order? First prayer A. Second prayer. Commanding respondent to restore possession 93 acres of land such and such. Under which provisions of law? And what is the challenge? And what is the relief?
First prayer is vague, cannot be answered.
Yes. And second prayer is restore. Under which provisions? Why it should be restored?
You want
I
to come
need to
back,
write in my prayer.
And my lord, prayer C.
come
That
back
I
with
need to
an
write on my prayer, your lordship.
You want to come back with an exception to this?
Yes, 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 your lordship.
Let him come back.
Yes.
Learned counsel for the petitioner seeks to use an exception to the report in the form of affidavit submitted on behalf of the seventh respondent. Paragraph, let the matter appear under the same heading.
তুমি কেউ না একুইশন তোমাকে পজিশন দেয়
আমি কি যে আমি রিপ্রেজেন্টেটিভ পজ দেবো একই হিসাবে পজিশন দিয়েছি আমি রিকোয়ারিং
In the monthly list of June,
Yes, yes, your lordship.
in the monthly list of June 2023, bracket on prayer of petitioner. First one,
Right, your lordship.
yes, first one.
Item number 9.
Item number 9 and 10, on behalf of Mr. Shomodi Biswas, I am praying for an accommodation, not today, my lord. My lord, I do not have any other instruction. I am only instructed that he could not come to court
My lord,
today.
the
He is not
subject
considered-
matter of challenge the order of order passed under the arbitration. Well, that is, it is appellable order.
That, your lordship, the main prayer is that they should have received compensation and the right to fair compensation act. I have the award with me. The learned arbitrator has in fact decided that the award,
Arbitrator has decided the award.
that it has to be in, as per the right to fair compensation act itself. So where is the grievance? I do not understand of the petitioner. Insofar as the structure value is concerned, the arbitrator has said that the rate will remain unchanged. They should have challenged the arbitral award.
কোনটাতে দোষে
নয় নয়
নয় তো আমি আছি গো
দশে আমি আছি আমি দশে আছি
কি নাম তোমারটা উৎপল উৎপল সরকার তো
একটু নামটা বল
Let it be
আমি তো
dismissed.
উৎপলে আছি
But kindly record my submission, my lord.
What
And-
submission?
I
Are
have
you
paid
the
for
advocate
it.
on record?
No, my lord. I'm
Then
only
how are you making
instructed.
the
তোমরা
submission?
দোষ
I'm only instructed, my lord. Kindly,
yeah.
just, he could not come for personal difficulties. It's only instructed that,
State's already gone.
Lordship, on 3 occasions they have not appeared and
my lord kindly
don't
grants
seem to-
only not today, my lord. I can request him to definitely
Let
attend.
it be not today, I'll dismiss it tomorrow. If it's not ready,
In,
not today.
not today.
Item number 10.
9 and 10, your lordship is similar.
9 and 10, not today.
টেনে কি আছিস
একই
হুম।
Item number 11.
My lord, I appear on behalf of petitioner. My lord. My lord, item number 11, your lordship, Mr. Anand Banerjee is appearing for the. My lord, my last occasion, 23rd day of my lord, March 2023, you lordship got the order. My lord, here, my lord, it appears from the report that the order passed by this court on 10th June 2018 has not been complied with. No inquiry upon the giving the petition opportunity hearing was made by the DM. But where, my lord, what has happened in this order? My lord, this, my lord, the date, my lord, 10th day of June 2018, my lord, by typographical mistake, my lord, it is written. But this order ordinarily be, my lord, 10th day of July 2019.
You've not pointed it or I dictated it in court.
No, my lord, last occasion, my lord directed, my that order, earlier order should be complied with by the DM. My lord,
Yes.
kindly see the last order, my lord, 10th day of,
2018 order.
no, to July. 10th day of July 2019. But this order, my lord, is reflecting the DM has to make inquiry.
10th of July 2019.
Point out, sir, the order was dictated in court.
My lord,
The
here
date-
in this case, my lord,
The date has been wrongly recorded in the.
wrongly recorded in the order,
The author have pointed this out.
wrongly
It
appointed.
was dictated in court.
My lord, I could not hear, my lord. Both of us, my lord, I could not hear. My lord, kindly excuse me, my lord.
10th July 2019.
Yes. 10 July 2019, this will be.
Yes, a joint inquiry was directed. Has that been done?
According to me, have been done, man. But today I am not with that, my lord, so I told my.
No inquiry, my lord, my instruction.
I will feel.
So, my lord, further date may be given. My lord, my indicating the order, my lord, 10th of July 2019.
To some time, my lord, I can produce that.
Kindly mention that order date. He order to correction.
Correction করে নাও।
It correction.
Correction. আমাকে একটা copy দিয়ে
Inadvertent
দাও।
error has crept into the order passed on 23rd March 2023. Paragraph in the said order, 10th June 2018 be read as 10th July 2019.
19, my lord. Great.
Paragraph, the department is directed to make necessary corrections accordingly. Paragraph, this order be treated as part of the order passed on 23rd March 2023. Paragraph. Learned counsel
That
for the
order
state
was passed by,
Yes,
that order was passed by Honorable Justice Kalundar.
yes.
Yeah.
yes.
How it will be corrected?
না না corrected now. এটা ভুল করে অর্ডারের মধ্যে লেখা হয়ে গেছে অন্য ডেট।
In the last order, instead of 10th
Oh.
July 2019, it was recorded as
Yes,
10th
ma'am.
June 2018.
Yes, ma'am.
The learned counsel for the state respondents seeks further accommodation to comply with the order passed on 10th July 2019. Paragraph, let the matter appear under the same heading on 15th June.
Yes, ma'am. 28 June. 28 June.
28,
15th June.
15th June. I'm grateful to your lordship.
Item number 12,
My lord, Mr. Ponchon has appearing on behalf of petition, my lord, he is sick, my lord. So, my lord, over telephone, I have been, my lord, requested to take adjournment for a week. Please.
After vacation.
After vacation, as your lordship.
On prayer of the petitioners, the matter is adjourned. Let the matter appear under the same heading on 8th June.
My lord, I'm grateful to you.
item number 13,
But another state. My lord, I appear for the petitioner, my lord.
Yes.
My lord had directed the state to file a report, my lord, regarding the status of
Mr.
the.
Kotakal, you're ready with.
Yes, madam. My report is ready, madam.
Have you
My
served?
Yes, madam. On the আগের দিন করে দিয়েছি।
No, no, no.
Have you received a copy?
No.
একটা কপি আছে।
না না আগের দিন রিপোর্টই করেনি
Yes, what is the matter about?
Well, may I go through the report, my lord, then
And
come
then
back?
come
My instruction is your lordship pass on similar matter, your lordship pass this order, my lord, your lordship can dispose of it. Their matter, my lord. In their matter, similar matter,
খুব জাহাঙ্গীর আলী কেন এই অর্ডার পাস করেছিল
our authority has admitted that they are entitled to get compensation, my lord. Only when a direction is necessary from your lordship,
এটা দিয়ে দাও।
ভারতবাসী,
But in the,
ভারতবাসী, তারতবাসী।
in another matter, similar type of matter, my lord has passed also this direction.
ওরাই দিয়ে গেছে। হোল্ড করেছে যে ওরা entitled। এই অর্ডারটা দিলাম ওই গভর্নমেন্ট থেকে order গেছে। এটা থেকে তো কোনো
কিছু বলো
The amount has been decided.
Yes.
The amount of compensation has been assessed.
not assessed, my lord. They have, my authority has decided that they are entitled to get compensation. my lord.
But that is the repetition itself.
Your report?
Yes, my lord. My report I have stated.
But that is in the
Yes,
writ
but
petition, we
percentage
have already stated, my lord, they have decided that the petitioners are entitled to get, my lord, the compensation.
Yes.
Thereafter, nothing happened, my lord. That is our grievance in the writ petition.
That is why I'm saying, my lord, kindly, my lord, pass order in terms of your lordships, my lord. On the similar issue, your lordship, my lord, decided this matter, my lord. Their matter, my lord.
My lord, kindly keeps it another day, my lord. I will consider the report and come back, my lord. It's better, my lord.
Let it be disposed of. Why do you want another day?
But
You are entitled to compensation. Yes. So let that be paid within a stipulated time frame.
my lord, will kindly consider the order, my lord. I have handed over October 1st, my lord, 2021, my lord.
At page?
But now I have handed over.
Yes.
Passed by your lordship, my lord.
Here the amount has been decided.
My lord.
There was only a direction for payment of the amount. But in your case,
Is yet to be decided.
it is yet to be decided. It has not been assessed as
Let
yet. Let it be assessed and paid within a stipulated time
My lord.
frame. Why do you want to waste for the time?
My lord, within a stipulated time frame.
Yes, of course.
Difficulty, my lord, unless the order is served upon us, assessing the amount, my lord, under which act they will give or what amount they have will give, my lord, that has to be first communicated to us, my lord. Thereafter, my lord,
They will communicate, my lord. They will communicate, my lord.
and thereafter they disburse, my lord.
Let them assess the amount and communicate the same to you.
My lord.
Invite your objections if
My
any.
lord.
Yes. It will be sufficient if they communicate because you can file your
My lord.
objections.
In some matters, my lord, they did not communicate even. They asked for the
Assessment of compensation along with other statutory benefits have not been made as yet. Is submitted on behalf of the state respondents that compensation along with other statutory benefits be directed to be assessed by the should be assessed by the special land acquisition
Special,
officer.
yes.
By the special land acquisition officer, comma, South 24 Parganas, comma, being the third respondent herein in accordance with law. Paragraph, in view of the above, the writ petition is disposed of, directing the third respondent to assess the compensation along with other statutory benefits payable to the petitioner in respect of the plot in question, respect of the plot which is the subject matter of the writ petition, within 1 month from the date of communication of the order. Stop. Such assessment be communicated to the petitioners in order to enable them to raise objection, comma, if any. That should be sufficient in this writ petition.
my lord can fix a time frame, my lord. If objection is not filed, they will disburse, my lord. Because, my lord, then in that event, I have to come again, my lord.
Another 3 months for disbursement.
My lord. Yes.
Paragraph, in the event no objection is raised by the petitioners to the said assessment, comma, the assessed amount of compensation shall be disbursed in favor of the petitioners by the 5th. No?
This one, 3. So 3 good.
By the same respondent?
Same respondent, man. This was 3.
by the third respondent.
But
within
let
3
it by the,
months.
most probably, my lord, the collector, second respondent will disburse the amount.
Special land is the authority, my lord. My
Disburse also?
Yes, my lord.
Disburse also.
disburse কি করবে? Recording body তো disburse করবে না।
না, রিকভারিং বডি তো করছে। Special.
Within 3 months thereof.
Yes.
Good.
অর্ডারটা দেখে নি এইটা চিন্তা এইটা মাইনে এটা কম আমি ফোন করব
Keep your.
Item number 14,
Yes. Who is appearing for the petitioner? You're appearing?
Well, I have served the notice to the Sushovan Sengupta for the government advocates, and also as per direction, my lord, I have served to the respondent number, last 3 respondents,
7, 8 and 9.
7, 8 and 9, and my lord, on the last time directed to bring the latest server report, and it shows that it has been served and received. My lord, the first order was passed in the writ petition, my lord. My lord, item delivered, my lord. The latest track report has been submitted.
Mr. Guchait and Mr. Roy were appearing for the state.
Partho Sarathi Roy and Guchai.
Partha Pratim, yes. So why
I have
not you
served
serve?
twice. I have served twice and submitted the said letter. But they are not interested to submit report or comply with the earlier order passed by His Lordship Justice Bosak. Directing the respondent number 3 and 4. That if the structure in front of the said petitioner soldier is situated on the Gram Panchayat land, then that shall be removed. That is the order, first order passed by Justice Devanshu Bosak, middle para. First para directing the BLRO respondent
Your
number.
track report doesn't show service.
Track report showing.
Item dispatched, item received and item,
Thereafter, my lord directed me and I filed the latest report. That is the same number, Gram Pradhan. First one, Gram Pradhan. Thereafter, the beat officer and the private respondent. All 3 items delivered,
yes.
my lord.
But what
They are
about
not
the state
interested to
status?
oppose, my lord. They are in a wrong foot. They are not interested to oppose.
Maybe, but the state has to be there.
The state is not complying with the order of the Honorable Court.
Have you
My lord,
served the
kindly
state?
see the first order, my lord,
Have you
kindly.
served the state?
I have served the state.
Where is the services?
That is in the record. Partho Sarathi Roy and Guchai. Twice I have served, matter adjourned 3 times before this bench.
What is your prayer?
My lord, my prayer is to remove the illegal structure, page 18, my lord. My lord, I am a soldier, I have purchased a land, my page 26 is the sanctioned building plan. Page 26 is the sanctioned building plan granted in my favor by the Gram Panchayat. But I cannot put the materials inside my structure. That is page 27 again, the obstruction, and page my lord 29. That is the request by the second command of the military colonel to the district magistrate not to harass the petitioner soldier. And thereafter the district magistrate, page 30, my lord. After 29, my lord, 30, the district magistrate issued letter to the superintendent of police to remove the illegal structure.
In spite of the request of the district magistrate, the police is not doing, and thereafter I have made the demand justice. My lord, my prayer is at page 18, the jhupri may be removed in front of the drain, hanging placed on the drain, and I cannot put my materials inside the set my plot. And the
Have you submitted a representation before the authority?
I have submitted, my lord. And the my lord also directed, my lord, kindly see the order of the Justice Devanshu Bosak, my lord, kindly. The respondent number 4 shall assist to the SDO. The respondent number 3, the first order in the writ petition. And thereafter, the second para lists the writ petition in combined monthly list of November 2019 under the same heading when it have the report as called for by be filed. In the event the respondent number 3 finds that there exists any encroachment on government property, he will take appropriate steps for the purpose of removal of the same. And if required, he will inform the appropriate authority for the purpose of removal of the same in accordance with law. That is the police help. So the BLRO submitted report that it is an illegal encroachment on the government land.
Where is the report?
That report is lying with the advocate. And he is not appearing.
You filed a contempt application also?
I have filed application, and that time, actually, my lord Justice Devanshu Bosak was pleased to found that the writ petition is pending and the order passed earlier by the state lordship, that is an interlocutory order. So the contempt should not be proceeded at this stage unless the writ petition is heard out. My lord, let there be a direction. The wrong person may be dealt with in accordance with law. The SDO is the appropriate authority here. It is a village road. SDO is the authority who can deal with the BLRO or the police or the panchayat. All the 3 persons are under the SDO. They are the drawing and dispatching officer, SDO, in all the cases.
Will it serve your purpose if the SDO is directed to?
My lord,
consider your
my lord, I think they will do it. They will do it if your lordship directs. In the middle portion of the earlier order, it is said that if it is found it is illegal on the village road, then it should be removed.
Where is your representation before the SDO?
My lord, my representation is at page 31 by the petitioner, and thereafter in the demand justice 31, and thereafter page 34. Demand justice, district magistrate, superintendent of police, BLLRO officer in the Gram Pradhan, etc. SDO also given. SDO also made party respondent number 3. My lord, if your lordship directs, they have received the writ petition, they are the state respondent, they are the appropriate authority. Keeping pending of the writ petition will not help anybody.
Absolutely. So let your representation be disposed of.
My lord,
In terms of the order of this court.
my lord, in terms of the order, in terms of the earlier order passed by the Justice Devanshu Bosak, the middle portion, this can be the final order, my lord. If it is found illegal, they will demolish. So there is no illegal direction upon the SDO. In consultation with the BLRO, the SDO can remove it.
Very well, let this be the final order.
My
Let
lord,
this be the final order.
let that be the final order, my lord. I am grateful, my lord.
Affidavit of service. None appears for the respondents despite service. Paragraph. The petitioner alleges illegal construction on government property adjoining his property, thereby obstructing him from utilizing his property. Stop. In an odd paragraph, in an order passed on 22nd August 2019, this court directed the third respondent to hold an inquiry as to whether there was any encroachment on government property as complained by the petitioner. Stop. The said respondent was granted liberty to take the assistance of the fourth respondent in identifying the government property and encroachment, if any. The court further held that in the event encroachment on government property was
Public road.
appropriate steps would be taken for the purpose of removal of the same. Upon informing the appropriate authority, in accordance with law. Paragraph, since the respondents have not found it necessary to contest the writ petition or put forward their contention herein, the writ petition is disposed of in the light of the observation made by this court in the order passed on 22nd August 2019. Paragraph. Accordingly, the third respondent is directed to hold an inquiry, as to whether there is any encroachment on government property adjoining the petitioner's property, as complained of by the petitioner. Stop. The third respondent is at liberty to take the assistance of the fourth respondent, who shall assist the third respondent in identifying the government property and encroachment thereon, if any. Stop. In the event such encroachment is found, the third respondent shall take appropriate steps for removal of the same in accordance with law. Paragraph with the above directions and disposed of.
A time limit may be given.
The entire exercise should be completed within 3 months.
2 months is sufficient. As you know, 2 months is sufficient.
There has to be a demarcation also.
BLR is
There
there.
has to be a demarcation, a proceeding has to be initiated that it takes.
As your lordship.
That takes
As your lordship.
from the date of communication of this order. Paragraph, since the respondents are not represented, the petitioner is directed to communicate the order to the respondents at the earliest.
Fine. I'm grateful, ma'am.
They'll have no knowledge otherwise.
My life, sir.
Next.
Item number 15.
15, I am for the petition.
Railways. Yes, madam. State.
The petitioner is the owner of the land,
Yes.
the 2 plots in Mauja, Sirampur in the district Malda.
As
The-
per report of the railway authorities and the state of West
Lordship.
Bengal, the land has been
Let me
acquired and
submit first. They are constructing the road over the land of your petitioners without acquiring the land of the petitioners. My lord, report filed by the respondent number 3, kindly see the first report.
Yeah, okay.
Report by the state?
State,
Yes,
common affidavit, respondent number 3.
yes.
Can you see the paragraph 4? It appears respondent number 3's report. This is the first report. Second time they filed another report.
Oh, you're referring to the first report?
Yes. Filed by Onsuman Chakraborty, respondent number 3.
Yes. Yes, page?
Page 3, para 4. It appears from the statement made in the petition in paragraph 1 and 2 that petitioner citizen of India claiming to be a owner of the question in plot number such and such, Moja such and such, in Kaliachok district Malda, measuring 18 decimal of area. Say land is allegedly purchased by the petitioner ancestor but transferred from the LR record the Samsul Haq Momin, not Samsul Haq, the owner of the Khatian number. The Samsul Haq Momin, Samsul, both the same petition name of the petitioners. Thereafter, kindly come to paragraph 6. Paragraph 5. Paragraph 3 and 4 that the divisional railway manager, Eastern Railway, being the respondent number 4, being claiming that plot in question railway property and started construction on the road under state project over the said land without giving any notification and notice to the petitioner. Paragraph C, the last portion, I further state that the construction of the road over the suit plot is illegal and void since the same were never acquired by any law acquisition at any point of time. Thereafter, the second report filed by the state. Kindly see the last occasion they filed the report. This is the report. With respect of the question subject matter, the petition report submitted of the end of the plot number 1583, 1584 Mujab Silampur, GL number such and such, but a LA case number 7 of 1963-64 has been found that area of 0.37 acre out of 38 acre of the plot number 1583 and 28 acres out of 37 acre plot number 1584 have been acquired by the compensation, and the compensation has been paid to the Abdul Jabbar on 23/6/1965. Copy of the instance LA case along with award list reports special training collector Malda are hereby attached for ready reference. Earlier report submitted is totally based on a read of LA case number such and such, which has been inadvertent mistake and unconstitutional apology in that regard is begged for. The kindly see the report. Kindly see the award. Award of the land acquisition collector 1964. CS plot number in part, they acquired in part 1583. There is no 1584 plot number. And last portion is here, plot number 1583 measuring 1 decimal, respectively, assessed.
What is your plot number? Your plot number is?
158384. In the award, only 1583 is mentioned here, in part. As per report, award, it is reflected that only 1 decimal has been acquired in the plot number 1583. Remaining plot are recorded in the name of the petitioners, and they have converted the bagan to market recently in April 22. The respondent number also filed report on our affidavit and actioning this document also they have annexed in their reports. Same document.
It's only 1583 is there.
Yes, yes.
In the last portion, measuring respective land, last 1 decimal has been allowed.
Yes.
I'll see my exception.
Where do
There-
you find the 1 decimal in 1583?
This is the last portion. The plot number and measurement, measuring. Plot number such and such, so many plots are there and measurement is there respectively. Has been allowed.
Partly accurate. Notification is between.
Yes.
Only 83 is there. I have filed my exception to that report. Kindly come to paragraph 8. The petitioner states that the LA collector which has been annexed P9 is the aforesaid affidavit. We said that it has been stated that plot number 1583 measuring 1 decimal of land has been assessed and awarded. But respect to the annex 11, it has been stated that LA case number such and such herein 30 acre land acquired by and total 38 acres of land such and such account file is totally this was collected copy of the award. Therefore, report filed by the different number 4 is contradictory. Kindly come to the annexer. The 4 deed I have annexed 4 deeds, which the petitioner is the owner of the land. Kindly come to
Report of the railways and the state are contradictory.
yes.
Well,
Page
second
34.
report
Kindly come to railway record of right.
same.
Second.
The second report is same.
Page 34.
1583, 1584, measuring 35 decimal and 23 decimal, total 50 decimal name of the petitioners.
Yes.
Thereafter converted the land into bagan into market. Page 36 P6. 9 decimal of land converted into bagan to market in April 22. 11th April 22. In LR record of right, that petitioner name has been recorded long ago.
Yes.
So it is reflected that only 1 decimal has been acquired, others land is
One of
owner.
the plots.
Yes. This is my case.
Well, kindly come to our report, page 16 of our report. Well, this is the letter issued by Special Land Acquisition Collector Malda to the railway authorities. Page 16 of my report.
Page 16, yes.
Now kindly come to paragraph 4 of the that page. Paragraph 4. On scrutiny of LA records, it is found that plot number 1583 as stated above was acquired by LA case number this and this to the extent of 0.37 acre out of 0.38 acre, and plot number 1584 was acquired to the extent of 0.28 acre out of 0.37 acre of land wide LA case number. In this case, the requiring body was the NF Railway, now Eastern Railway. The connected notification was made by number this and this dated 30th November 1960, and declaration was made by number this and this dated 19th October 63. The compensation for the above acquisition was paid to one Abdul Jabbar.
But this doesn't tally with the government, the acquiring authorities. report.
Lordship, the same.
Please come to
Acco-
page,
Yes, Lordship, kindly the second report, my lord,
yes, second report. Please
The
come to
what?
the award part.
on respect of the already award pass, LA case number such and such.
Please come to the award part,
Lordship.
not your statement.
My lord,
Statement
my lord, before that, kindly come to page 24 of my report, that is the notification. Page 24 of my report.
Yes.
My lord, kindly see the second paragraph, survey plots in part. Both the plot numbers are mentioned there. Second line from the bottom, my lord.
Yes.
Both the plots are there.
This is the section 6 declaration.
Yes,
Plots.
ma'am.
Mhm.
And my
And
lord,
this doesn't tally with the state's report.
tally করছে না?
Because the state has acquired.
The same, my lord.
Please show me your document.
According to the report, the gazette notification, kindly see
Page.
Page বলুন।
page number not mentioned, my lord, the LA case number 12 or 1960-61, my lord.
That is not the LA case at all. 12 is the wrong LA
Yes,
case.
yes,
This is what-
LA case number 7 of 1966.
LA case number 7, my lord. The plot number such and such,
Where is your document?
Page ফাইল করেছে?
already filed, my lord, kindly.
The land acquisition, this fifth page.
Yes, yes.
LA case number 7 on the report.
Oh, so wait, have you filed this document? Yes. Yes.
The plot number is same.
But please come to the next page.
এই পেজটা এখানটা মনে হয় কেটে গেছে। এখানটা মনে হচ্ছে না কেটে গেছে। এই যে 8.3 এর পর 8.4 হয়তো ছিল কেটে গেছে।
8.3 and 8.4, my lord.
I think it is not legible actually. 8.4 was also there, I think. 1583 stroke.
Can't make out. In the last part, called number 3, there also only 1583 is there. After that is 1613. Even if you have acquired for argument's sake, where is the compensation?
Compensation already paid to one.
Where is the document showing payment of compensation?
Documents. It is stated by the state that they have paid the compensation.
Yes, the documents is there. Kindly.
The
Page,
compensation.
oh, this is your, it's in the report.
Abdul Jabbar, such and such already paid by CC voucher number 34 on 23rd June 61. LA collector Malda.
এখানে দুটো প্লটই মেনশন আছে।
There are two
Where is the
plot is mentions there.
Where is the document?
This is the document. The award copy, my lord. Jabbar, one Jabbar, my lord.
Have you annexed this document to your report? I do not find it.
Let's see. তোমাকে দিয়েছি না ওই কপিটা? I already hand over to the.
Oh, yes, which is there, Abdul Jabbar.
Two plot is clearly mentioned, my lord.
There are discrepancies in that page that have shown only one plot
Let
is
it be
there.
considered by the
The other plot is not there.
district magistrate কে দিয়ে কনসিডার করে নেবে।
So lordship won't come for verify the further.
Have you seen?
I
this
already
page?
copied the.
Yes, yes,
Say that they have paid compensation?
yes, yes. But no signature is Abdul Jabbar. There is no signature of Abdul Jabbar.
Yes.
The tick mark only is here.
Yeah, 61.
See the amount paid to
Paid
date and
by-
the payment.
CC.
Paid by CC voucher, that is.
Voucher number
But in
34.
award only 1583. Award is
1583 and 1584 both.
Yeah, it was.
in
there,
award,
but it
award.
was not
In
legible.
award, yes.
But-
both are there.
But in the receipts,
In
it
the
show that,
receipts, both are there.
but it is reflect only the 1 decimal.
So you.
It
you
is
cannot
contradictory.
claim further. I don't think there is anything left in the writ petition.
Let them send to the authority, they verify.
65,
Always. This is the document.
Yes.
we are in 2023, when did
But,
you file?
but
it?
land is in my possession. Till date.
But part of the land has been acquired.
It is partly acquired.
Yes,
That is the
kindly,
case.
kindly direct the survey the land which was they have acquired there.
It will
Can-
make the for demarcation.
Yes.
You pray for
Yes,
demarcation,
yes, yes.
another writ petition. You file the another writ petition for demarcation.
Can I,
And
this,
then
this
the
will can we,
replacement
can,
report the
can,
competent authority
can order
for
can be passed
demarcations
in
of the
this.
land. Dispute is more or less 1 decimal.
In award only 1583.
You file an application for
See the
demarcation.
receipts.
তুই আছে এখানটা
টুকুই আছে।
একটা
আরে না, এখানে আছে, এখানে কোথায় থাকবে? এখানে তো থাকবে, ভিতরে তো থাকবে। 151613 করে তো থাকা উচিত।
আরে এটা পেমেন্ট নোটিশ, ইট ইজ দ্য ভ্যালিড ডকুমেন্টস।
Once they file report that their land has been acquired.
Their report prima facie suggests that it has been acquired and compensation has been paid to your predecessor. You can only pray for
But-
demarcation of the.
Yes,
because
yes, yes.
it's part-
But
part
not,
of the-
not entire plot, not has been acquired. This is my, yes.
partly
Yes, yes,
parts
yes, yes.
acquired. So there can be, can at best be an order for demarcation.
Yes, 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 my lord. Let me demarcate.
Let the writ petition be disposed of
Yes,
with
yes,
such
ma'am.
an order, because nothing further is.
No, no, my, yes, my lord.
Alternate counsels for the parties. The petitioner complains that the railway authorities have constructed a road over the petitioner's property without acquiring the same. Stop. The reports submitted on behalf of the respondents demonstrate that portion of plot numbers 158 and 1584 have been acquired and compensation paid to the predecessor in interest of the petitioner for the same. Stop. Since the plots have been portions, since the acquired portions have not been demarcated, comma, the land left for utilization of the petitioner cannot be ascertained. Paragraph. The petitioner prays for demarcation of the acquired portions of plot numbers 1583 and 1584 in order to enable them to utilize the unacquired portions of the plots. Paragraph. In view of the above, the BLLRO will demarcate. The BLLRO will demarcate.
What's the land acquisition? The land acquisition officer is the competent officer.
Demarcation.
Special land acquisition officer. Surveyor is there. But
He is not a party to the writ petition. Special Land Acquisition Officer is not a party. Will you include him as a party? I'll give you liberty. Let him be added as a respondent.
Lord Land Reform Officer is the party. That's number 5.
He says Special Land Acquisition Officer.
Yes, I meant.
Yes, একদম শুরুতে করুন তো, on prayer of the petitioner. Liberty is granted to include the Special Land Acquisition Officer. Malda.
Malda.
As respondent number 8 in the writ petition. Paragraph, the constitution of the writ petition be amended accordingly. In view of the writ petition is disposed of, directing the 8th respondent to take necessary steps for demarcation of the acquired portion of.
Remaining non-acquired portion of that.
You cannot demarcate non-acquired, you have to demarcate acquired
be
portion. How can
demarcated
you demarcate private land? You have to demarcate your portion. Demarcate the acquired portion of the land in plot numbers 1583 and 1584. In presence of all the stakeholders, including the petitioner / his authorized representative and the railway authorities, comma, in accordance with law.
Also, according to the prayer of the petitioner for payment of the compensation does not arise at all at state.
It has been paid. I have stated that
Already
we have paid the compensation. I am not passing any other order. It's only for demarcation. So that he can utilize his portion of the land. Is disposed of matter ওখানে একদম সুজিটা করলাম accordingly directed to court. So represent in accordance with law. Within 1 month. Mr. Motor, within 1 month.
1 month.
1 month.
Within 1 month from the date of communication of this order. Okay. Paragraphs. Since nothing further remains to be adjudicated in the writ petition, comma, the writ petition is disposed of. There shall have been no rest of us which are length. Demarcation within 1 month.
Item number 16.
For the petitioner, the person of the Mylar Soda is not even completed. Track report not even received. I think from 1 week adjournment, my lord.
Track report not received.
No, track report
Time
not,
was for
track report not even completed, my lord.
So will you come back after vacation?
Yeah.
Since service upon the private respondents is not complete, your opinion? Mild, I'm happy. And let the matter appear under the same heading on 14th June.
14th June. Yes.
Item number 17.
17, my lord, I am appearing for the petitioner, my lord. Last occasion, there is direction for filing of reports.
So there your report.
এই দেখুন এই দেখুন হ্যাঁ এই দেখুন কপি দিয়েছি আবার ডিমার্কেশনটা করে দিলেই হয়ে যায় ল্যান্ড অ্যাকোয়ার করেছে এবার পার্ট অফ দিস প্লট তারপরে কি
Destroy your report.
But I have not been direction to file report, my lord.
Mr. Day is supposed to file the report subject to correction, my lord. On the last occasion, my lord.
Say is supposed to file the report, is not. So there no report. Please come back, Mr. Yes.
Well, this is only for the purpose of demarcation. A portion of the plot was acquired. No.
My lord, kindly allow me, lord, to file a report, my lord.
No. Actually.
আমি কিছু চাইছি না। So the portion of the plot is has been acquired. Now, my lord, there is an amalgamation of the acquired portion and the unacquired portion. So it is demarcated nobody because we are the co-sharers of the plot of land. Now somebody is saying this, I have the entire to get the entire portion. That is a so that's why, my lord, I sought for with your lordship, the report may be called for that what is the portion acquired. After that, my lord, if your lordship wants, my lord can pass the direction for demarcation of the plot of land in terms of this. Yes, yes. Huh? Plot demarcation টা
Acquired and unacquired portions.
সেটা না করলে কি হচ্ছে?
Then the total apportionment will come.
Yeah, after that, my lord. Otherwise, my lord.
Learned counsel for the state respondents seeks
Yeah?
further extension of time
দিয়ে দেবো দাদা।
to submit the report in the form of
আমাকে কোনো না
affidavit as
বলেছে।
called for.
প্রথমে উঠে বসে একটা। হ্যাঁ,
After vacation,
As your lordship, please, my lord, it is now I have hand, Mr. Day.
second extension is the
8 June,
8 June, very well. 8 June.
just after vacation, my lord.
My report is required, my lord.
আপনাকে দিদি কোনো ডিস্টার্ব করছি না। দিদি অলওয়েজ ভয় থাকে।
Report দেওয়ার জন্য।
Yes, next one. State.
This is my application. There was an acquisition followed by award by the competent authority. Then, my lord, I sought for, my lord, the arbitration. Now, lordship, kindly turn to the page 24 once.
24.
Yes.
Yes.
Now, kindly see the signatory, that who is the litigant before the arbitration. He is sending me the notice for arbitral award.
The competent authority.
Competent authority. He is a litigant.
Yes.
He cannot send any notice to me.
He's a party. Yes.
He is a party to the arbitration proceeding. Now, my lord, if you lordship kindly turn to the, my lord, the in National Highways Act. It is given Joseph. Can we look at the subsection 6, subsection 3G? Subject to the provisions of this act, the provisions of the Arbitration and Conciliation Act 1996 shall apply to every arbitration under this act. Then lordship kindly turn to section 31 of the Arbitration Act.
Of the Arbitration Act.
Yes. Section 31. Then only I can take the recourse of, my lord, section 34.
Members of the Arbitration Act. Yes.
Yes. He has to sign. Because I tell you, lordship, why? If your lordship kindly turn to, your lordship has already dealt with this type of the order of the arbitrator. It's a general order without specifying my entitlement. So in that score also, the award is also bad.
You are
Yes.
not given an opportunity of hearing before the arbitration.
No, I was, but my lord, fact remains that
Not bad insofar as you are concerned.
no, bad in the sense, my lord, declaration of the award, because he has to put his signature on a award in respect of mine only. There is no award so far I am concerned. Your lordship will not find from here the name of mine.
Individually.
Individual award that is to be passed, that is the law. Because all the provisions of the arbitration contract will apply.
Yes, Mr. Mondal, have you served the award individually to everyone?
Call for the report.
Let me come back. Two issues. Individual award, you've not complied with the
Provisions.
provisions. Individual award signed by the arbitrator has to be served. Have you done that? Number one. Secondly, this page 24, notice of payment was made by the competent authority. Under what authority? The ADMNA doesn't have the authority to issue such a notice. He is a party to the arbitration. And his order has been challenged in arbitration, isn't it?
Yes.
Please come back with a report clarifying these issues. The grievance of the petitioner is twofold. Colon dash. Copy of arbitral award has not been served upon him in terms of Section 31 of the Arbitration and Conciliation Act 1996. Stop. Notice of payment of arbitral award has been served upon him by the ADM within bracket LA bracket close Nodia and competent authority under the National Highways Act 1956. Who is a party to the arbitral proceedings. Paragraph learned counsel for the state respondents seeks to submit a report in this regard, report in the form of affidavit in this regard. Paragraph, let the matter appear under the same heading after vacation. 12th June.
Item number 19 and 20.
In second matter, my lord, 20, I am appearing for the respondent number 5, who has been given the work order of running the ferry ghat boat. My lord, pursuant to my lord's injunction order, in spite of we have made payment around, my lord, 62 lakhs in September, and
This is going on for last 1 year.
just 62 lakhs around, my lord, we have already paid, deposited. Thereafter, my lord, we have not been handed over the possession, my lord. The poor members of the cooperative society are suffering. My lord, kindly look into that. Because
My lord, Mr. Supratim Dhar is appearing on behalf of the state respondent in item number 19, my lord. My lord, there is a maintainability issue pleading that this application, entire proceedings has been initiated in terms of section 280, rule 281 of West Bengal Land Reforms Manual. Hence, in terms of section 2R of the West Bengal Land Reforms Tenancy Tribunal Act 1997, this instant writ petition is not maintainable before this Honorable High Court. The petitioner should have approached before the learned tribunal, my lord.
Has been dealt with on several occasions by this court. There are earlier orders also.
My lord's order. Now, my lord, I am armed with my lord's order.
My lord, kindly permit me to argue on the maintainability issue, my lord. My lord, may I continue, my lord, with it, so that Mr. Supratim Dhar can come and
Please decide the order prior to that, because I will not pass an order beyond that.
My lord, one thing, my lord, I am also not in position. The ferry is running by some other, but the problem is, my lord, whether this Scottish society and the cooperative society who can be participating in the proceedings. It has opened door to all the cooperative societies. Then, my lord, what they're doing, that they are now curtailing the same restricted to the boatman cooperative society. That is not permissible. This is held by this honorable court also division bench. That I will argue, but I am not entitled to go into the merit of the very threshold, my lord, on the ground of this maintainability by the raising by the state.
My lord, here, my lord, the successful, my lord, the tenderer is a boatsman society. That is true. My lord, the other tenderer who have deposited, they have not been declared successful.
Yes, he has completed his argument.
This is the work order, my lord. We have paid, kindly have a look to. It is, my lord, in September, just before passing of my lord's injunction order. Since this,
I think he has argued on the same line as Mr. Dhar proposes.
My lord, kindly have a look to the order, my lord. We have deposited, we are the poor members of the Boatman Society, my lord. Since, my lord, September, my lord, we have not been handed over the possession, my lord. We are very much suffering, my lord. We are, my lord, we have deposited 62 lakhs, my lord, with the government, and the government is enjoying the money. And we have not been handed over the possession. The agreement has been executed in between the officials of the, my lord, state and also with us. My lord, kindly protect us, my lord. We are the Boatsman Society. They have made us party respond number 5.
Yes, the writ petition is disposed of.
My lord, difficulty is what Mr. Rai is taking, that the other tenderers, those who are the construction company or something like that, they have also participated in the tender process. My lord, I would say, my lord, they have not been declared successful. They have not been declared successful in respect of my tender, where I have been declared successful. In 2 ghats, my lord, we have been declared successful. We are the Boatsman Society. We have deposited money. We are not concerned with any other, my lord, whoever is granted, my lord, the tender, who is not a Boatsman Society or the hereditary partner, my lord. We are suffering for this, my lord, the order, my lord. My lord, past, my lord, already 9 months, I suppose, my lord, 8-9 months passed. The poor members' money, my lord, is lying with the government, with the state.
In the first matter, you are the private respondent.
In the second matter, respond number 5, that is 808464 of 2022. Agreement was, my lord, executed in between the government officials with us. In spite of that, the person, whoever is running, he is running without any tender, nothing, my lord. They are enjoying. And our hard-earned money, my lord, that is kept deposited with the government. And not
Then, my
only,
lord, I have to place on the matter on merit, my lord. Then, my lord,
another thing, my lord,
Issue first, my lord.
my lord, another thing I would indicate, my lord, with regards to this writ petition, my lord, there is a criteria.
my lord, on merit, my lord, if my learned friend is inviting to argue on merit, then I have the scope to argue on merit. So let my learned friend.
He is on the maintenance.
My lord, kindly protect us, my lord. Kindly protect us.
The government return the money, and the person from whom.
After, my lord, after 9-10 months, we have lost our interest and everything.
Because of
It's the poor man's money.
ineligible person has to be granted. That is that has to be decided by your lordship.
You are appearing for?
In 20, I appear on behalf of the respondent number 6. But I am the only eligible society in that locality. My
Everybody is saying, well, that's time this division bench I have handed over to your lordship, that Adinganj, Jiaganj, Boatman Cooperatives, how this should be considered and what is the parameters for the purpose of selecting the Boatman Cooperative Society. There it is held. To understand whether any other local boatman cooperative, the submitted provision was forced at the time when the petition was applied to settlements of such ferryguard. So in view of the substituted provision, we feel that the concerned authority, before issuing notice inviting tender, should have ascertained as to whether any local boatman cooperative society or partnership concern formed by the local boatman and heritage party 7x the petitioner cooperative society is available in the locality or not. That exercise has not been done. And what happened, my lord? All other cooperative societies are allowed to participate. This is one sort of big reading by the state. Yes, this is judgment. This is a judgment which is yes, division bench judgment, my lord. I have handed over to your lordship, pursuant to which, my lord, is privacy, because they produced this document from where it will appear, my lord, not in the construction cooperative. Everybody was allowed to participate. Now the price has been high by these persons. And the poor cooperative, there the cooperative society is just something in front, but the person who was there.
Come back on affidavits. Contention of several, I mean, everyone claims to be the only entitled person.
Yes.
The maintainability issue will be kept open.
My lord, actually, initially matter was being heard on the point of maintainability. I had concluded my submission. Mr. Dhar had something to add to it. My lord, only thing is that, my lord,
Please come back on affidavits because there are several submissions to be made, I find.
My lord, Land Reforms Act, Land Reforms Rules and Land Reforms Manual cannot be treated as a separate it's a part and parcel of the act, my lord. Hence,
Whether
in terms of section 2
are
or
we
my
not
lord,
or not?
Decided earlier, sir.
my lord, there are other judgments which are.
I would request you to
my
post
lord.
this judgment.
My lord, kindly protect us, my lord.
I believe a judgment was referred before the honorable division bench also.
My lord,
And-
there are subsequent judgments as well.
As your
There are subsequent judgments as well, my lord.
In your lordship's file, my lord, I have already relied on a few.
the subsequent judgment that,
Please do.
yes, my lord.
My lord, this is the subsequent judgment.
Please come back on affidavits.
Ma'am.
I do not find any other alternative.
My lord,
Because
kindly protect
yes,
us.
government is the government who is.
Protection, sir.
My lord,
because
difficult-
Interim order has to continue, which is already
My
there.
lord, difficulty is, my lord, difficult.
Otherwise, the book that it
For
is-
last 1 year, my lord, this interim order is continuing, there is no challenge. My lord knows, my lord, once there is
My
two
lord,
provision.
difficult-
Either not vacating, not being challenged. It is allowed to continue for last 1 month. And if your lordship kindly consider order certain in rule 4. Merely, my lord,
Kindly one thing, my lord, kindly one thing I would indicate, my lord, whether on the date of advertisement, the petitioner, the society was at all eligible, because from the record,
that is not merit, my
My
lord,
lord,
not my learned friend.
my
is
lord, my lord,
subject to merit.
kindly appreciate one thing, my lord. Before my lord asked, my lord, perhaps these things was not brought to my lord's notice, my lord. Because my lord, the tender, let me complete, Mr. Roy.
No,
Let me complete.
then my lord, this sort of argument, my lord, without raising an objection, my lord, this is not permissible, my lord, subject to correction.
My lord, kindly from their record, I will not produce any document from my side. From their writ petition, my lord, I would show, my lord, that my lord, the tender term says, my lord, 3 years, my lord, my lord,
I'm sorry, I'm not on merits at the moment. because
my lord, kindly record my submission, kindly record.
Now come back when after evidence.
My lord.
My lord, kindly protect us. Otherwise, my lord, kindly direct the state respondent to whatever the money we have deposited, that would be kept in the interest drawing account. Because, my lord, for last 10 years, 10 months or 9 months, we are suffering.
Lord, they are saying this at this stage, my lord, from the beginning, they have not said this.
Yes. Now
My lord,
this cannot be
my lord, this is,
accepted.
my lord, it is transferred.
You can't slap on after the
My
order.
lord, difficult.
1 year, last is continuing, my lord,
No,
there is
no,
no
no.
challenge. On the contrary, as on the
It
ground
was
of
in
mandate,
September.
my lord was
It was-
reduced
My
to.
lord's order was September. My
Why?
lord, it is
But that is
transferred brief
the
to me,
reason-
my lord. That is the difficulty. My lord,
Transfer brief.
my lord, it is true. It has not
It
been
has
pointed
preferred an
out.
appeal, my
It
lord,
is-
kindly
my
consider.
lord,
Your lordship was initially refused to pass an interim order. I preferred an appeal, my lord. This appeal means it is fixed for hearing on such and such day. The mandatory point, the honorable judge, I was pleased to observe that this judgment should be considered before considering the next date of hearing. Considering that all the things are good before your lordship. Subsequent to satisfaction, my lord, it is not the interim order on the very first day it was passed. Drop of.
Otherwise, my lord, the money may be refunded to us.
You can take it up with the government, not in this court.
My lord, since
Yeah.
my lord's pursuant to my lord, since my lord's order is there, my lord, when my lord is adjudicating the whole issue, my lord has to equilibrium with the justice.
I want to take up the entire issue as a whole.
Yes, my lord, but in the meantime, my lord, in the meantime, when my lord has passed my lord, kindly appreciate one thing, my lord, kindly appreciate when my lord passed an interim order, we are the most sufferer because, my lord, in spite of paying our money, my lord, we have not been
Challenge the order.
My lord, difficulty is there, my lord. I know, my lord, what is my predicament. But since, my lord, I have newly entered into this matter, my lord, difficulty is, my lord, when, my lord, this, I would able to invite,
The state.
yes, my lord, kindly direct them to refund us.
Yes.
Yes. Yes, that may be done.
Difficulty here is that, my lord, from September, they have not complained against the interim order. From September, they had their opportunity. If they're prejudiced by the interim order, they could have preferred an appeal. They have not done anything.
That is true.
Today-
That is, I cannot say, my lord, that I cannot
My
avoid.
learned friend, I appreciate. My learned friend, I entered into the matter today, but the matter is not new.
Yes,
So today, the private respondent is seeking an interim order on the state.
I would suggest that approach the state, request the state.
Yes, it is.
My lord, our request, my lord, when my lord is saying and requesting the state to, my lord, the state is denying, my lord, then our request will not suffice the purpose, my lord.
Paragraph affidavit in opposition be filed within 2 weeks. Within 2 weeks from date. Stop affidavit in reply, comma, if any comma, be filed within a week thereafter.
My lord, kindly record my submission and pass necessary orders, my lord.
What submission do you?
My lord, I have handed over the documents showing that I have been,
Submission.
Opposition is left
my lord, interest bearing account, I'm not claiming the refund. Kindly appreciate this.
2 weeks to 3 weeks.
My lord, it will take us another, my lord, 5-6.
That's the government.
My lord, kindly appreciate, my lord, pass necessary order so that my lord, it will not prejudice anybody, my lord.
Extended till 30th June.
My lord, it will not prejudice anybody, my lord.
Granted earlier is extended till 30th June or until further orders, whichever is earlier. Paragraph, the issue of maintainability is kept open.
My lord, one thing, my lord, kindly add, my lord, the amount we have deposited, that would be kept with the government in an interest bearing account, my lord. Otherwise, my lord, we are.
And
we are
Mr.
the most sufferer.
Betal's client was there before the honorable division bench.
Yes, I know the predicament, my lord.
It's not that
they-
behind his back, any order.
They never
Yes,
pressed
I-
this.
Yes,
Now, my lord, after such a long time, now they are renewing their
my
prayer.
lord, where is the
What has
difficulty of,
prompted them?
my lord, where is the difficulty of,
Order now that the honorable
Yes.
division bench will consider whether it is right or
Yes.
wrong. Next matter, please.
the difficulty is my predecessor, my lord, has not pointed. This is the difficulty.
Item number 21.
I'm for the petitioner. Well, your lordship kindly give me accommodation mail for 1 week. Well, I have to use my supplementary.
Service has not.
Service complete.
Ha. Service complete.
No, 5-6 sir.
Or service has yet not been completed.
Char
my lord.
5-6.
4-5.
Service is completed?
No.
No.
Char 5.
No.
Char.
Please come back.
Yes. No, your lordship kindly give time.
Since service upon all the respondents is not complete, let them understand over till 13 June.
My supplement with my lord, liberty to give in panel to file supplementary.
Paragraph of prayer of the petitioner, liberty is granted to use a supplementary affidavit annexing relevant documents.
My grateful.
Item number 22.
I am appearing on behalf of the petitioner, my lord, led by Mr. Anand Banerjee, my lord.
Yes.
My lord, in this matter, my lord.
Who is appearing for the ECL?
My lord, my lord, in this matter, I have challenged that the ECL utilize my land without taking any permission or any acquisition from the petitioner, my lord. And we have annexed the photograph also. And from the photograph, it is clear that they have utilized my property by digging the earth and constructing a room, my lord, in page number 16 and 17. And in their report, they have also admitted in paragraph 8, page 2, in their report, they also admitted that they have constructed a 120 square feet asbestos shed for transformer room, my lord. Subsequently, they shifted the area, my lord. It is admittedly they have right now they have shifted the but my lord, they have utilized my property. Presently, I am paying the rent compensation for that period, and kindly grant the liberty to us to file the appropriate proceeding before the civil court, my lord, against because there is probably the writ court.
For that, liberty is not necessary. The law gives you the liberty.
No, actually, my lord, if the writ court has already given, they have taken that point on that civil suit that already writ court has given that we have filed the deed, and subsequently the court has already passed an order, so we don't have.
No, the order will not be on merit.
This is for
Civil suit, you always have the liberty.
and they have already admitted that they have constructed a 120 square feet asbestos shed in my property, my lord, and my in the photograph which is annexed to my writ petition, my lord, it is clear that they have utilized my property by constructing the asbestos constructing a transformer room and digging the property, my property, my lord. And we have annexed my record of right, page 14, my lord. I am the owner of that property.
Yes,
Kindly come to para 8 of my report, my lord.
you have practically admitted the.
Yes, my lord. But what is, my lord, has been done, my lord, we have admitted before, my lord. We have come clean before your lordship, my lord. My lord, what happened, my lord?
For the damage.
But compensate, my lord, my lord, they made a case out of trespasser, my lord, of encroachment, my lord. Admittedly, encroachment has been removed, my lord. Now, my lord, it is not that, my lord, we have.
Does that absolve you from the responsibility, from the liability?
My lord, kindly see, come to para 8, my lord, what I have said, my lord. But I say, my lord, 120 square feet of asbestos set as transformer room was built in the corner of the set plot, northeast corner. I say that at the time of construction of the set, no measurement was conducted. Because whether measurement was not conducted, my lord, that mistake has happened, my lord. Construction of the set measurement was conducted and the area was found barren land. I further say that during the construction of the set by the hire agency, the mining contractor, my lord, the coal contractor, my lord, whom we have given, my lord, they have done this mischief, my lord. My lord, nobody came forward to claim the ownership of the said disputed land, nor anybody resisted or halt the construction. I say that as soon as we came to learn about the said dispute, we immediately vacated the land and demolished the said structure and restored it back to the petitioner in its original form. And now the particular position of the land is where the asbestos shed was built is free from all encumbrances. I say, my lord, that the payment of compensation does not arise as the petition land is unfit for agriculture and as the petition land is a barren land. The nature and character of the portion of the land which was by mistake the ECL contractor has built for an asbestos shed for transformer room has been restored back to its original form and character, my lord. But there, my lord, it was a barren land, my lord, and yes, we have really encroached a portion, my lord. Now, my lord, we have restored it back, my lord. But I have also annexed, my lord, the photograph, my lord. My lord, nothing has been taken, my lord. In my report, my lord, kindly see, my lord. This was the land, my lord. This was the land which was been encroached, my lord. Your lordship see that there was a grass, my lord. Previously there was grass, but now, my lord, while we have built, my lord, the grass was not there, my lord. So, my lord, it is in this position only, my lord. My lord, there is no pecuniary loss for the petitioner, my lord, and nor they have made a positive case before your lordship in this writ petition, claiming that this damage has been made or this amount I am entitled to. There is no pleading, my lord.
Admit encroachment.
Yes, my lord.
What follows?
At 120 square feet, my lord, what compensation should we pay, my lord? We have restored it back to its original position, my lord. Your lordship knows encroachment, my lord, trespass, my lord.
Claim before the civil court.
My lord, your lordship
Under rain
can open.
compensation, I am paying rain compensation for for utilizing my land, because in my photograph page 16, my lord, we have
That's I deny my dispute, my lord. Because I have also shown.
we have constructed that the construction is evident from the photograph, my lord.
Where?
Yes, page 16 and 17.
But your land doesn't look like agricultural
That is not the
land in
land.
your photographs also.
Because, my lord, and
Disputed question of fact, my
because
lord.
this is my land, my lord, my client is presently residing in New Delhi, and subsequently they
The
came
barren
to learn that his property is encroached by them. They have come before and
Talk
before.
about agriculture.
Yes, my lord, because
Where is the agriculture in your land.
because before utilizing that land, before that the photograph is not with me. It is admitted case. Presently,
Not admitted, my lord. The photograph is not admitted. What they are showing, my lord.
Do the photographs suggest any kind of cultivation at any point of time?
Because this is it is the land nature is Kanali.
Anali, my lord, is not an
mentioned-
agricultural land.
Let this case be disposed of. Approach the civil court
Yes.
with your.
And the
case.
rain compensation, because they have admitted, my lord,
If
they
there is
that
any
they
problem,
are
they can
they have
ask for
utilized
the
my
civil
land.
court, my lord, and they can show the nature of deviation and everything, my lord. But
Admittedly, this is my land, my lord, and they
is
have
required,
utilized my land. It is they have admitted, my lord.
But we have
And my
encroached the land, we have
photograph, it is
removed the
already
encroachment.
clear
This is
that
our
they
case.
have constructed a room in my land, my lord. I am paying the rent compensation for that, and after subsequently we have approached the civil court, my lord, because the appreciation of evidence is necessary to. I have admitted that, but they have utilized my land. It is admitted fact, my lord.
In order to basis, there should be a basis of compensation also, my lord. That also has to be pleaded
It
in
is
the
my
petition,
lord,
my
it is admitted, my lord, and they have utilized.
Some compensation to the petitioner.
Yes, my
Let
lord.
the authority decide on it.
But
I'm not fixing any amount. I'm not
Yes.
assessing the compensation. Let me
my lord, then kindly do one thing, my lord. Send us to us, my lord, we will give them a hearing and let them assert before us how much loss they have incurred, my lord. We'll decide that and we'll they decide.
So will you file an application in that case before the?
Kindly grant me a time frame, my lord. We have to, if you, time frame.
That is not required. Assess the compensation upon hearing them.
Yes, my lord. Kindly direct them that.
120 square feet, my lord, we have removed the enforcement. Nothing else now.
The petitioner complains that a portion of his land has been utilized by the Eastern Coalfields Limited by excavating the same, resulting in continuous soil erosion. The petitioner has claimed rent compensation from the company for utilization of his land. Paragraph.
But restricted to 120 square feet only, my lord. Our pay is also that, my lord.
I'll repeat your submission. Placing reliance on the report in the form of affidavit, paragraph, submitted on behalf of the third respondent, comma. It is counsel for the ECL submits that admittedly an area of 120 square feet of the petitioner's land was utilized by the company for
By mistake, man. By mistake of the contractor.
by raising an asbestos shed for a transformer room the shed has been removed and the land returned to the petitioner in its original character. In its original form. Learned Counsel says that such mistake happened due to the fault and negligence of the contractor of the company. Paragraph, since encroachment upon the petitioner's land for land has been admitted by the ECL, comma, the ECL is directed to pay rent compensation to the petitioner for such encroachment within 2 months
Yes, my lord. Let them have a say
from
how
the
much.
date of communication of this order. Stop. Such rent compensation shall be assessed by the authority upon serving notice upon the petitioner and hearing them on the issue. Disposed of. Utilize, pay some compensation.
Item number 23.
I am for the petitioner hearing. But I am for the West Bengal Mineral Development and Trading. Lordship, this is the petitioners. Before Lordship, the petitioner was declared as highest bidder in an auction proceeding. And the petition was, accordingly, the petition was directed to pay the 1/3 bid amount. The petitioner could not pay. And the petitioner wrote a letter. And subsequently, an order has been passed cancelling my bid. Thereof, the petitioner again made an application to pay the bid amount. As on that, Lordship, the subject to consent of my learned friends, petitioner intend to pay the entire bid amount in 2 installments. This is my
prayer, Lordship.
Authority has to decide.
Lordship.
The court
I had
cannot
made an application. Lordship, kindly come to my applications dated such and such.
It's the prerogative of the authority and the authority has to
Obviously, Lordship, the subject to consent of my learned friends.
cannot impose anything. Where is your application?
So the application, Lordship, kindly come, page 38. Last representations. Lordship, before that, kindly come to the impugn order. Page 36. It will be clear. Lordship, the second para, it appears that he was the highest bidder and highest bid amount rupees such and such, and he submitted such and such, while participating in an auction process as security deposit. He was requested to pay 1/3 bid amount by such and such, but he did not pay the amount. Later, another demand come hearing notice such and such issued, but he did not deposit the amount. 6 months elapsed, but he did not pay. And for this reason, Lordship, kindly come the next turn. Hence, the authorized undersigned has no other alternative but to cancel his highest bid by date and such. Therefore, it is hereby ordered that the highest bid award in favor of the petitioner such and such is cancelled, and the money which is deposited for taking part in auction is forfeited. So thereafter, I made an application on April 12, 2022. This is under consideration, and in this application, I made an application for remaining 1/3 bid amount. But as on date, I have been instructed, even Lordship, the petitioners intend to pay the entire bid amount in 2 installments within 3 months.
I'll record your submission.
Lordship.
Let the application be considered with this.
It has already been terminated. Man, it's a applicable order. Let him clear the paper appeal under section 51.
Whatever it, Lordship, this is the applicable order, or this is
A paper appeal before the authority. This is under section 51
Lordship, these are only on the score of technicalities.
of the minor concession.
Right, it's a district magistrate.
Lordship, then my submission kindly be recorded, Lordship. Otherwise, I will be prejudiced because the appellate authorities will say that why did you not make
Was
submission?
given my lot opportunity of hearing, was called
No,
for
I am
to
not
deposit,
going-
asked him to deposit.
Petition on this ground.
Lordship, I am not going on the merit. First of all, I am saying this is the apologized petition. I have lost my opportunity, and that's why, Lordship, the petitioner come before Lordship.
It has, prior to termination, this could have been considered. Once it has been terminated, a final order has been passed, it is applicable.
Lordship, appellate order, whatever, Lordship.
So, this court will not help you.
Lordship, all right, Lordship, kindly my submission be recorded.
Please make an observation that the order is applicable.
Lordship, my submission kindly be recorded.
Cannot be recorded.
Because
Cannot be recorded, I'm sorry.
otherwise the petitioner will be highly prejudiced. Then the appeal court obviously will be say that why did you not
Two
make
options,
submissions?
you have to either dismiss or you have to either withdraw or have to dismiss.
No, Lordship,
Dismiss will give you an opportunity to approach the appeal court.
no, Lordship, obviously I should prefer an appeal. Then in that event, Lordship, the delay which has been which is
That will be
called.
conducted. District Magistrate Purva Vardhaman on 26th August 2021 is assailed in the writ petition. The said order is amenable to appeal under Rule 51 of the West Bengal Minor Minerals Concession Rules, 2016. Paragraph in view of the same. The writ petition is dismissed as not maintainable. However, the petitioner is at liberty to approach the appropriate forum for redressal of his grievance. Paragraph, in the event the petitioner approaches the appropriate forum within 15 days,
Lordship.
within 15 days from date, the appropriate forum shall deal with the appeal on merits without dismissing the same on the maintainability issue. That liberty can be granted. This was.
Wait.
There shall, however, be no address to costs or other such matters.
Lordship. Grateful. Great.
Item number 24.
Item number, my lord, 24, I am applying for the state respondent. My lord, if your lordships kindly take it next week, my lord.
Yes.
What is the matter?
Matter not encroachment by the private respondent or the government land, not your lordship direct them to consider and not consider the yes. Now your lordship only thing. Yes, yes. No, we don't. Only your lordship kindly see last page, annexure.
Give me a minute, please.
Your lordship kindly the private respondent sub. Lordship kindly see page 34, last page. Private respondent, your lordship kindly evidence page 8, so that your lordship can take page 8.
Yes.
Yes. Now, your lordship can see last page of the deed petition.
Yes.
But the observation of the subdivisional magistrate, your lordship kindly see that as per the BDO Korimpur, his report, it is observed during the course of inquiry that encroachment by the respondent is not making hindrance in the ingress and egress of the petitioner. Encroachment is admitted. Now, as per report of the inspector in charge, Korimpur PS, there is every chance of breach of peace, any type of removal encroachment. And status quo. Lordship, it cannot be. Like lordship is
Section 10.
yes. Set aside the order and your lordship. Yes. Your lordship on the just page 32, your lordship order is there. Page 32. On the basis, yes.
Very unfortunate.
Yes, that's very unfortunate.
Affidavit of service. None appears for the private respondent despite service.
Is due.
The order passed by the subdivisional magistrate and subdivisional officer, comma, Kehoto, comma, on
Let us comment and correct.
4th April 2022 is essayed in the repetition. Paragraph. In an earlier petition, WPA 24463 of 2018, comma, the petitioners complained unauthorized construction by the private respondent by encroaching upon government land. Pursuant to an order passed by this court on 2nd December 2021. Directing the third respondent therein to consider and dispose of the representation submitted by the petitioners within 3 months from the date of order, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioners and the private respondent, comma. The matter was taken up for consideration by the concerned authority. Stop. By the order impugned, comma, the subdivisional magistrate has held that the private respondent has encroached upon government property. Stop. But at the same time, the order indicates that such encroachment is not hindering the ingress and ingress of the petitioner, and there shall be chances of breach of peace if if the encroachment is sought to be removed.
এই কি এটা একটু অ্যাডমিট না ওই যে পাবলিক ল্যান্ড এনক্রোচ করা আছে
The concerned authority has directed both the parties to maintain status quo on the said stretch of land, comma, meaning thereby that he has in fact acceded to the encroachment made by the private respondent. Stop. Such conduct of the concerned authority is not only unknown to law, comma, but is absolutely unfortunate. Paragraph. Section 10(1) of the Section 10 of the West Bengal Highways Act 1964 is set out. Section 10. Section 10(1). Paragraph. नहीं कोई আপনাদের কাছে আমার কাছে কোনো inverted comma open করুন 10 within bracket 1 if any person comma hyphen a next line small a next line is found to have made an encroachment on any road comma street comma path comma way or land which is declared to be a highway under the subsection within bracket 1 of section 3 comma or next line b small b within bracket makes an encroachment on a highway in contravention of the provisions of section 8 comma or c next line small c does not remove an encroachment on the expiry or cancellation of any permit granted to him comma the highway authority or any officer authorized by him in this behalf shall serve a notice on him requiring him to remove the encroachment and restore the highway to its original condition within the period specified in the notice. Stop, inverted comma, closed. Paragraph in view of the above, comma, this court is inclined to hold that since encroachment by the private respondent upon government property has been found, comma, the concerned authority is directed to initiate proceedings under section 10 of the West Bengal Highways Act 1964 fourth and take the proceeding to its logical conclusion within 2 months from the date of communication of this order upon affording reasonable opportunity of hearing to all the interested persons including the petitioners and the private respondents, comma, in accordance with law. Disposed of.
And your lordship not set aside the order, set aside this order.
তার আগে একটু দেন in view of the same যেখানে বললাম ওইটা কোটেশনটা করা the order impugn passed by the subdivisional magistrate and subdivisional officer Tehatto, comma Nodia on 4th April 2022 is set aside.
Grateful.
Right. Unfortunate.
My lord, I am tendering my unconditional approval.
Not that.
My lord,
status quo order
There is encroachment.
everything, my lord, so far government is, my lord, so far government is, everything is unfortunate.
Everything is unfortunate.
We have to,
I wanted to add a few more lines which I registered.
my lord, I think, my lord, because I was not there, all right. Lord.
Continue with encroachment.
Yes, that is not permissible.
You have allowed that to happen. Next matter.
Grateful.
Item number 25.
25, my lord, in this matter, my lord, I am appearing for the petitioner.
Well, this
See,
matter, I
well-
think, so একটু বলতে দে আমাকে 2 মিনিট বলতে দে। Well, this matter, my lord was hearing the matter, at least I think, well, 10 days. So for 10 occasions,
Puri property.
yes, it's Puri Papa. My lord, here my submission was simple at that point of time. Again, I am making that submission that no public law element is being involved. So writ petition doesn't lie. Second, they want to implement the clauses incorporated in the deed, the settlement deed. My lord, that cannot be implemented. There cannot be any mandamus directing the authority to implement the provisions. Number 2. Number 3. Number 3. Title suit is pending. My lord, we have searched about the person concerned. My lord, I have to be candid before my lord. The person concerned died. So, my lord, so far, only that knowledge I have got. My lord, I do not know anything whether that petition was dismissed for default or not. I have got no information. So, my lord, on the basis of my lord, the representative petition, I am humbly submitting. First, my lord, no public law element is being involved. Number 1, because in a rich jurisdiction, at least, my lord, there should be a public law element has to be involved, because otherwise, my lord, no writ lies. This is a very fundamental things, my lord. But my lord, why I am saying there is no public law element is being, why? Because they filed this purported petition. By filing this petition, they want to implement a clause in the, my lord, settlement deed. That is not permissible under the law, because my lord knows that if yes, my lord, there are various honorable apex court judgments, and my lord knows that yes, if there is a violation of statutory laws, if there is a duty cast upon the authority in terms of statute, my lord can exercise my lord's discretion. But my lord, there is again up to 2023, the line of demarcation between the private law and the public law still remains. My lord knows that judgment. Even 2021, 2022, 23, I did not go through whether the law has been pronounced on the basis of that issue. Well, 22 up to 22, the law is settled. Even there is a fine line of difference between the public law remedy and the private.
Property is handed over to the state.
Property was handed over to, yes, I am saying what I am saying. Well, suppose a lease was executed. And my lord, if this is not a statutory lease, my lord, there may be a statutory lease, then writ can be enforced. My lord can exercise my lord's own jurisdiction. But my lord, if this is a private law limit, I am submitting, subject to HON'BLE submitting, subject to my lord's approval, that the deed which he is to enforce it through a court of law is not permissible, because deed itself has got no statutory flavor. Maybe state, my lord, kindly consider, maybe state is being involved in every case. But Supreme Court decided that the line of the judgment says that if there is no private law, if he insists for judge, then I will bring that judgment.
Yes.
But then I will bring that judgment next day. But if he insists that, then I will bring that. There is now again at the cost of repetition, the line of difference between the public law remedy and the private is still remains. That line of judgment I will bring.
Involvement of the state.
Yes, I will.
Now,
my lord, state, maybe, my lord, state is, so far tender is concerned. I am taking it hypothetically. My lord, kindly take into account. State is a party to that. Even Supreme Court, my lord, refused to accept that, because they, in that case,
Why don't you come back with the judgment?
I will bring that judgment on.
my lord, one thing, my lord, kindly turn to their decision, page 11, supplementary affidavit.
Supplementary.
Yes.
We are seeking for implementation of
Page 11, access C. Whether anything remains after this. I put this question to myself.
I am disputing that. The
Huh?
The government will change and the decision will change.
Well, no, my lord, yes, if, my lord, something.
My lord, it is not,
Suppose, my
it
lord,
is an executive government.
my lord, suppose there is.
The executive government.
I know that's principle of law. Suppose there is a mistake on the part of the, my lord, the earlier government. Can it not be rectified? Well, I just put that question to myself. The state already made. My lord,
One thing, my lord,
state, my lord, kindly consider, we want to improve that or the.
আর দরকার নেই।
দরকার নেই।
When was the resolution?
My lord, they kindly see.
91.
91. My lord, kindly consider one.
Till 2020.
My lord,
And that's
suppose.
the direction of the municipality that.
Suppose I am a state.
Life loss must be done at any point of time.
Suppose I am a bad person. I have not implemented that. My lord will decide whether he can, by making an application under Article 2, he can implement the clauses incorporated in the settlement deed. He can file a suit. He is not remediless. He can file a suit. He is not remediless. I could have understood he was remediless.
Return of the property since you have not been able to.
My lord,
And
on
they
the,
have
on what?
decided.
No.
They have
What-
decided.
But I just put that on what basis? On the basis of that clauses in the incorporated in the deed.
Basis of your admission.
Admission, my lord, that I say I am reverting, I am saying that this is not at all an admission.
Is there any subsequent resolution to that effect by your government?
Yes, I have handed over one copy, my lord, which says, my lord, I have handed over a copy that. Yeah, I am disputing that.
Disputing. This is the copy
Yes.
of the written instruction. May I read out for your lordship?
I am disputing that.
Due to non-cooperation, my lord, can last paragraph onwards. The civil court case, the revenue service force could not able to complete the construction work at properly. Several meetings were between the trustees, Mukberi Ganga Trust, transfer ownership of the property, but the writ petitioner did not agree with the proposal of the government. Has already spent huge amount. I have on the earlier occasion, I have shown to your lordship the date which was mentioned, and before that it was decided it will be handed over. Project never been completed as yet.
Please show me one line to say that you have, you are not supporting this letter.
I am not supporting. I will make an report in the form of evidence. I will
Okay.
not supporting that.
Okay.
My lord, this
Yes, that is my contention.
today is
Written
11,
instruction
12
says-
days, my lord, it is running.
Written instruction says that. But only thing, my lord, kindly.
Let him come back with this public element, private element.
Yes, private law remedy, public law remedy. Yes.
And that-
Yes, I will, my lord, I am not on that. I am on the point of law.
Let him come back with the judgment.
Yes.
Regarding maintainability.
Yes.
পর্যন্ত দেয়নি এর আগে অর্ডার দিয়েছিলেন
আজ পর্যন্ত
Judgment এর কথা কোনো-
আর judgment আলাদা order লাগবে?
আরে
না, আগে
judge-
তো argument
আমি-
করলে সেটা।
আমি তো বলে দিয়েছি, জজ সাহেব বলেছিলেন যে
ও,
ওইখানে
ওপেন কোর্টে
My lord, only thing, my lord, kindly consider, on the last occasion, my lord told me whether the suit is pending or not.
So very unfortunately, you are making submissions which you are not able to support.
Yes.
You have spoken about a title suit, you took time, no title suit. Now you are talking about.
No title, my lord, whether suit is pending till
My lord,
date or not,
whether-
I have got no information.
My lord, kindly consider in one.
Yes, I
my lord.
have to be
What can
candid.
you consider?
I have to be
Whether,
candid.
my lord, 114 of the Evidence Act will prevail or the submission of Mr. Sengupta will prevail. Because he is
100
he is
for-
claiming
My lord,
title-
114. Yes.
I am the lesser, he is the lessee. I am the inducting lesser. So far detailed knowledge I have, my lord, 114 of the Evidence Act says you cannot challenge the title of the. So even if I have no title over the property.
No, I am not
Yes,
challenging the title.
The suit is pending, my lord.
Jeez, তুই বারে।
No, there is no question of
Oof.
dispute because there is nothing on there.
Yes, that is the, on the earlier occasion, it was the argument which was advanced by Mr. Sengupta.
It's no longer there now.
Now, my lord, he is forgetting that.
ও টাইটেল সুটের নাম্বার
ব্যাপারটা-
পর্যন্ত দিতে
My lord, I get the information that some suit was, title suit being such and such was filed. I didn't get any information. My lord, I have to be candid, I didn't get any information.
And one.
Yes, I will come back, my lord, finally
Listen,
take it
my lord,
on the
one thing,
point
my
of law.
My lord, one thing, my lord, record one thing. There is a notice from the Puri municipality that there is a, it should take steps, there's a chance of human life. loss of human lives. No, still our name is recorded in the, so henceforth the state will take the responsibility of the same. Because I cannot be axed in both way.
Yes,
So
yes,
record
I
that,
have no minor objection regarding that.
Yes.
Kindly record that.
There is the,
Later, my lord, এই যে, no. এই যে,
part of the repetition.
right, after that, my lord, it was.
After that, আমাকে দে, আমি
Mr. Roy, I cannot pass an order on. this.
Yes.
Come back by assembly.
তুই একটা senior হয়ে you don't.
Come back next week. Let Mr. Sharma.
Yes, my lord.
But I will bring that only judgment, my lord. Yes.
So that the repetition is not.
Not maintainable.
Only because is the implementation of the clauses in the trust deed. That is not, my lord, cannot be enforced in a written.
Record that is submission, otherwise, my lord,
Yes, I am saying that.
only that sub.
That will be longer than a judgment.
Yes, I am saying. Order never.
The counsel for the state respondents challenges the maintainability of the repetition on the ground that there is no public.
You put a copy of
element. Stop learned counsel seeks to produce an authority of the Honorable Supreme Court in this regard. Paragraph, let the matter appear under the same heading on 4th May.
4th May, my lord. এটা লিখে রাখ। এটা আগে
Judgment on.
I'll do it. I will hand over one
If
judge.
my learned friend wants, I can supply them my citation so he can prepare himself to counter me.
আর আমি
এই,
তোকে
এগুলো
দিয়ে
লিখে
দেবো।
দিয়ে দে তো।
হ্যাঁ।
এখানে এতগুলো আছে, লিখে দিয়ে দে।
আমি judge
Item number 26.
exchange, sir. My lord, I am sorry, my lord, I could not come at that point. Josh Sahib,
Next matter.
This is my lord, I am appealing for the petitioner. Here, my lord, the, I am for the response. On 26, my lord, the land of the petitioner was leased out to the Indian Oil Corporation when he was awarded also a retail outlet license, my lord, along with the plot of land which has also been let out to the Indian Oil Corporation. My lord, your lordship may kindly turn to page 24. Leased out to, because the condition is that I have to give that land pursuant to which I'll enjoy a retail outlet over of the Indian Oil Corporation over the said plot of land. The land belongs to me. I've been awarded with that license to operate, my lord. On that condition, I have to give that land. My lord, your lordship and draw your lordship attention. Page 34.
Yes.
Clause 3A, my lord, got it? Committed in breach of any covenants, condition herein, perform any of the event that shall be lawful. If there is any breach, my lord, I have to indicate them within 30 days. They have the right to rectify the same within 30 days thereafter. My lord will find. Now, my lord, skip over the same and kindly turn to page 37. Clause J. In event of the condition of the demise premises of any part thereof, or in event the failure on the part of the demise premises on any part thereof as a serving station and allied business being interfered with, handicapped by any law, ordinance, or rule or regulation of any government or authority, or by any order of the government, or in violation of the terms of the agreement, that the event of the demise premises at any time seizing the option of the lessee for any reason to be disadvantageous for the sale and petroleum product, the lease may be at written notice to the lessor, provided that the occurrence of a time during the subsistence of lease of events, circumstances according to provision of the clause entitled the lessee is determined the same, and failure on the lessor notwithstanding the occurrence of such events, circumstances amount to be treated as waiver right of lessee contained in this clause. So, my lord, if there is a loss or there is not in a position to continue with this business, then they will surrender the same. Now, my lord, my dealership has been terminated. That your lordship will find at page 50. It is at starts from 50, and it's a P6. I am drawing lordship attention. So for the page 55. The relevant penalty and that yes, I have done wrong things. So my dealership license stood cancelled.
You are the dealer.
I am the dealer. Pursuant to which, my lord, as a condition to that effect, my lord, I have to offer my site to internal corporation. They will act as a lessee with the right to enjoy, to operate that dealership in the said premises. Now, my lord, there is a 30 years agreement, my lord. Lease period is 30 years and a token rent of rupees 1,000 any escalation every 5 years. My lord, that is immaterial because 1,000 rupees be as it may, my lord. After cancellation of the same, I now requested the authority that already it has been closed. It is not been operated. So return my land because I can enjoy my property. Page 56 and SFP 7. Two options are given, my lord. If you want to take the land, take it by way of purchase. Page 57, clause I and II. These are the two options. Either if you want to take, you can take or release the land because it is not for. They have said in response to my letter, they have said we are not in a position to purchase the same. That your lordship will find at page 62. They sought for clarification. After that, my lord can turn to page 63. That it requires. Well, may I read out for your lordship, my lord? We hereby because that you offered the under consideration the subject premises requires approval for foreclosure of the existing legislation which needs approval from the higher management. Intimated regarding the purchase of land, once we get necessary approvals, we request you to kindly be in touch with us. After that, my lord, this is a letter for proposal, page 65. Though it is written to my wife, I am drawing lots of attention to the last page of last two paragraph, page 66. My lord got it.
Yes.
As the RO was terminated for proven violation of market discipline guidelines, we cannot withdraw the termination notice or making restoration of dealership of your husband as per the existing. This is the prayer made by my wife for
Ask for that.
now last portion. That's why, my lord. My wife, my lord, prayed, if you would, because it was initially in the name of that quota, Padmasri quota. She was allotted this quota. But as is terminated, she was, but that not I am pressing, neither are not there. In respect of the offer of selling, the last paragraph, my lord, where I am submitting, selling the retail outlet land, we used to inform that the land lease is still valid up to such and such. Yes, it is valid. Decision to purchase the land does not seem to be commercially viable at the moment. If at any stage we observe that we can purchase the land, we would definitely inform you on the same. We regret the corporation unable to honor your proposal of your husband to purchase the land at present. Well,
Is there any clause in the deed for termination of the lease prior to its expiry?
that is a clause which I have said that if it is not been continued, the lessee has the option to.
The lessee has the option, not the
Lessee
lessor.
has the option. My lord,
Lessor.
not the lesser. I must be continued.
Law doesn't give you an option.
Law in such a case, my lord, law does not give me an option. But what, my lord, the land,
There is the repetition in that.
this was released out to purchase because they are not in a position to operate this.
Can do that only after termination.
Yes, termination, my lord, only one thing, my lord, that's.
35.
Yes, what, my lord, I am praying before your lordship today is subject to my learned friends because the plot of land, they are not also utilizing. I am not also utilizing the same. So it is.
How can the court intervene?
What is fallen from my lordship, I bound on. That's why, my lord, very beginning I have submitted your lordship. This is the problem. So it is the resources which is in their hand. But ultimately, they cannot utilize the same also without my consent because it is my land also.
Let us see what they have.
If they,
Well, kindly sees the prayer. Man, the lease, it is an admitted position. It's a registered lease.
Yeah.
The lease is subsisting as on date. There is not a single complaint of any breach of the terms of the lease. But the well company, as per the terms of the lease, is entitled to occupy the property under the lease till it expires.
So Roy, I'm sorry, there's nothing in the repetition. It has to be dismissed. No merit.
so far, if
The prayers.
The return of the land, my lord.
Upon uninstalling the machinery, how? Under which?
Decision to purchase them
Upon
and
what
order nature manner commanding the respondent to release the land.
Your repetition is little premature.
Yes, my lord, if you are logically consider that in the clause itself, it says that if it is not operating or violating, my lord.
Equity cannot be beyond divorce the law.
Yes, ma'am. In the event of any portion of the device premises being taken up or acquired for setback or otherwise by authority whatsoever, the lessees shall be entitled to receive and to be paid compensation yes, of the portions are taken or required, inclusive the lessee structure or erection standing there, if any, on an appointment in accordance with law. So, my lord,
That is the case of acquisition. my lord.
acquisition, and also there is if it is not operating, my lord, can you consider that aspect?
Then even then the lessee has the option, not the lessor.
Yes, advantage for the sale of the petrol product, the lessee may. Well,
Not the lessor.
lessee may in written notice to the lessor provided that the
You can withdraw if you want.
this is nothing but
Proceed, you have the liberty. Nothing on merits.
no, my lord. If that be so, my lord, I must be a candidate for your lordship, my lord. So, but the law does not permit me to ask for any mandamus. I can persuade your lordship to.
After 2035.
Yes, 2035, my lord.
You can give them an option.
I have my lord's judgment is also there on that aspect.
After expiry. of
Yes, that is there. As it is the resources right idle.
Holding as of right.
So, my lord, may I pray one thing subject to question? If they can take it because it is pending before the higher authority.
Your representation has also been considered.
No, my
by
lord,
them.
that is pending, my lord. My representation so far is concerned. Page 56, my lord, is my
To your wife's statement.
wife's statement, my lord. No,
That is in
the two proposals, one proposal, my lord, will find that they have said that it is pending for adjudication before the higher authority. That your lord should find page 63.
Page 57 but this is subsequent. Page 66.
No, I'm coming. The page 63 is for the concept of the higher authority. Now, page 67 is that 6, my lord. But we could definitely inform you on the same. So, still, my lord, it is within their hand to take decision.
6 gives the answer.
Yes, in respect of the offer of selling of retail outlets, I said we used to inform that the land still is valid up to 139.
Purchase will inform.
The land does not seems to be commercially viable at the moment. If any stage you observe that we can purchase the land, we will definitely inform the same. We regret the corporation unable to honor your proposal of your husband to purchase the land at present.
এই পার্টটা থেকে দুটো প্রপোজাল দিলাম যে একটা হচ্ছে ওইটার একটা হচ্ছে আমাকে রিলিজ
Release তো বলতে ইয়ে হবে।
So,
As your lordship, my lord. It's
your option, your choice. I can just say that you do not want to proceed with the matter.
my lord, that will create. My lord can pass because my lord, even if today, my lord, if I went to withdraw the same, that would my lord pass the necessary order, which is for your lordship, my lord.
To be dismissed.
Yes.
Affidavit of service. It is contended on behalf of the petitioner. That the plot in question belonging to the petitioner was leased out to the respondents. Deed of lease executed on 11 July 2005. The deed.
Beg your pardon, my lord.
July 2005.
Yes. 30 years, 35, 2035.
And is due to expire on 6th November 2035. The petitioner was granted dealership by the Indian Oil Corporation for the purpose of running a retail outlet in the said plot. And such dealership was terminated by the lessees by a letter
6th April 2009.
on 6th April 2009. Stop. Since the plot was not being utilized by the lessees after termination of the dealership of the petitioner, comma, the petitioner approached the respondents with two proposals, dash, to release the property in his favor or to purchase the same at a consideration of rupees 1.5 crores. Stop. In reply to the said proposal, comma, the respondents informed the petitioner that since the lease is valid up to 6th November 2035, comma, the decision to purchase the land does not seem to be commercially viable at the moment, and they would inform the petitioner in the event they decided to purchase the same at any subsequent stage. Stop. Paragraph clause
The clause which I have shown to your lordship.
is the lessee's prerogative.
Yes, my lord. That is at page 37, clause J, my lord, subject to question. Last but one line, the lessee may add, my lord will find at the bottom. Page 37 at the bottom, my lord.
This is 3J, isn't it?
Yes, 3J, subject to question, my lord.
Clause taken there,
3J, my lord, 3J. At the bottom, my lord will find that
in this connection, comma, clause Roman 3, capital Roman 3, small j of the deed of lease may be reproduced. Page 37. Clause J to puro name, inverted comma.
for which lessee. J and K, my lord will find K is also at the option of the lessee to surrender or terminate the lease.
Page 38, 37 बोला तो 38 er contained in this clause. 38 er contained in this clause. Oh, you clause K of the deed, clause 3K of the deed. Also,
Option of the lessee.
entitles the lessee to determine the lease upon previous notice in writing to the lessor. Stop. Paragraph in view of the above, this court is inclined to hold that there is no provision in the deed of lease which entitles the lessor to terminate the lease prior to its expiry. Stop. Since the lessees have refused to purchase the property, to accept the proposal of the lessor for termination of the lease or purchase of the plot in question, comma. The prayer of the petitioner cannot be acceded to, comma, being devoid of merits. Paragraph, accordingly, the petition is dismissed. There shall have been no rest of
Only one main line. If they, in future, they think that they take up the property.
They have themselves stated that.
No, at present, it is not viable. Even in some, because once my lord is hold, then dismissal not to revisit their decision, because they have in their letter have said.
However.
Yes. That's the only thing that I want to, otherwise.
Dismissal, যেখানে বললাম না, ওখানে একটা line add করুন, however, dismissal of the writ petition shall not preclude the lessee from revisiting the proposal given by the proposal of the lessor.
Grateful to us.
Next.
Item number 27.
May it please your lordship's note, I appear on behalf of the petitioner. Lord, in an earlier round of litigation, when I came up before this honorable court complaining that the block development officer of Faridpur block, Lord, he has, Lord, constructed an eco park and pond over my land. My lord has granted me liberty, my lord, to make a representation, and if it is found that the land has been wrongfully taken up without acquisition proceeding, then compensation would be determined and paid to me. I made that representation. In view of that representation, my lord, the ADM, my lord, he has arrived at a decision, my lord, that compensation is payable to me, but then there is no determination of compensation, and he has relegated me to the Panchayat Samiti. My lord, I first take my lord, to my lord's order, my lord, which is, my lord, at page 41. My lord, it is not in dispute that the petitioner, my lord has very kindly got it, my lord. It is not in dispute that the petitioners are co-sharers in respect of plot in question. The petitioners complained that the said plot is being used for construction of eco park by the state authorities, but no compensation for the same was given to the petitioners. The petitioners pray for direction upon the authority to pay adequate compensation to them in terms of the Act of 2013. It is submitted on behalf of state that the petitioners may submit a representation to that effect before the third respondent, who shall dispose the same after considering the petitioner's case. Upon considering the submissions made on behalf of the parties, materials on record, the writ petition is disposed of with a liberty to the petitioners to submit a representation ventilating the grievances before the third respondent within a week from date. Third respondent shall consider dispose of the said representation within 3 months from the date of receipt of representation, after affording opportunity of hearing to all interested parties in accordance with law. In the event the petitioners are found to be entitled to the compensation, such exercise should be completed within a period of 3 months. But the exercise, my lord, that has been undertaken has resulted in page 55.
Yes.
This is 10th March 2022. Lord, kindly, Lord, comes to the third paragraph, not starting with the words ultimately. Ultimately, a spot verification has been conducted by this office on 3rd March 22 in the presence of representatives of BDO and the BLNLRO. It is learned from the report submitted by the LA surveyors of this office that the plot number is under jurisdiction of Eco Park.
They have admitted.
Yes. Then, though plot number so-and-so has been mentioned in the writ petition, from the record of rights supplied by the BLNLRO, it is observed that the name of so-and-so is recorded in Khotian number so-and-so. From the inquiry report, it's clear that suit land has been utilized for Eco Park, etc. As such, no LA case is found in the LA office. This is important. But the suit land has been used for Eco Park. Naturally, rent, compensation, land value is to be given to the landowners by concerned authority who has utilized, constructed the Eco Park over the said plot. During the hearing, petitioner have stated that the suit land is being utilized without any acquisition process.
Considering the whole matter and situation, instant proceeding is hereby disposed of with a request to the executive officer, Durgapur Faridpur Panchayat Samiti, to take a suitable steps. There is no determination under the Act of 2013.
Since it was not acquired, it has been utilized.
Yes.
That's why they have shifted it to the requiring body for compensation. Yes, what do you say?
My lord, first thing, my lord, government not requires, acquire the land. It's been clear, it is stated that as the no LA case is found in the LA
But it
office.
is admittedly utilized.
Utilized by the Panchayat Samiti, not state. The Panchayat Samiti, my lord, that is the resolution number 9. And the ADM LA is directed to the Panchayat Samiti to take step so that the petitioner can get the amount of the land.
When a land is utilized without acquisition, the requiring body has to deal with
Yes,
it.
yes.
My lord,
So let there be a direction upon the Panchayat
Panchayat Samiti.
Samiti.
my lord, kindly, my lord, comes to page 33, my lord, for a moment.
Yes.
My lord, this is, my lord, from the block development officer. My lord, he would kindly see, my lord, what does he admit? The construction work of Eco Park at so-and-so commenced in July 2016. At that point of time, we received no claim and objection from any person. We received no claim means the BDO is saying, he doesn't say so, my lord, that as an authority under of the Panchayat Samiti is saying so. And then kindly, my lord, sees on the day of formal inauguration, first phase of the park, one person named so-and-so forcefully entered. Then the next paragraph, on our part, we went through the application and placed a request before Sri Laha to meet the undersigned and settle the issue, if any, amicably. And who is writing this? The block development officer is writing this. Then kindly come to page 40. Kindly come to page 40. The BDO is writing this. BDO Durgapur Faridpur block development.
Yes, it says that we have no objection to return the land, the video,
Yes.
page 33. Yes, Mr. Concord. Please come to page
But the
33.
land belongs to, my lord, the Panchayat Samiti. Eco Park is constructed by the Panchayat Samiti, as it is alleged, my lord.
No, the allegation is not that.
The video says that they have.
My lord, previously one Pushporani,
Laha.
Laha, moved the writ petition. Your lordship passed the order. And accordingly, my lord, the inspection held, video has submitted the report. It is, my lord, it appears that the land has not been acquired, but it is utilized for construction of an eco park. Eco park is the authority, they have not made, eco park authority is the responsibility. But if it is, my lord, the eco park is constructed, my lord, by the Panchayat Samiti, the Panchayat Samiti is the necessary
Where
party.
is it said that the eco park is? Because please come to page 33 of the writ petition.
Yes, my lord.
The video admits.
London Friends client, my lord, abuse the language with the district magistrate. It appears to the record.
He must be angry.
Yes, my lord, that is true.
Please
But-
come to the last paragraph. of page
I have
33.
seen, my lord, the order passed by your lord.
We don't have an objection to return.
Pursuant to your lordship's order, my lord, it is, my lord, appears from the record of rights supplied by the concerned BLLRO, it is observed. The name of Narayan Chand Laha, son of Jyoti Laha, has been recorded in the LR Khutiya number such as such by. From the inquiry reports, land has been utilized by the eco park. It is admitted, sir. Land has been utilized and it is the land of the petitioner. As such, no LAT is found by the LA office, but the suit land has been used by the Eco Park. Naturally, rent compensation land value is to be given to the landowner by the conservative who has utilized construction Eco Park over the sale land. It is the the findings of the additional district magistrate land acquisition Paschim Bardhaman. During hearing, petitioners have stated the suit land is being utilized without acquisition process. Considering the whole matter, the situation, the instant proceeding is thereby disposed of with a request to the executive officer Durgapur Faridpur Panchayat Samiti. That is the video concern. No, executive officer video. Executive officer is the executive officer, but there are some other another the designatory, the Sabhapati Panchayat Samiti. They have not made party. Panchayat Samiti is not made party.
Not necessary. The
Executive officer, but it is a direction upon the request to the executive officer, Durgapur Faridpur Panchayat Samiti, Lauda, Paschim Bardhaman to take a suitable step and decision in this regard so that the landowner can get the proper valuation of the suit land, if not already. A direction be given to him, to my lord, to take step in accordance with law. Either they purchase or they pay valuation by the Panchayat Samiti. It is utilized, my lord, for construction of the Eco Park.
The executive officer has been made a party, they have not appeared.
Yes, Lord.
And the learned counsel says that he is the BDO, who has stated that they have no objection to return your land.
Yes, and BDO is a party. The Somiti is a party. Yes, yes. Respondent number 8, my lord. Then respondent number 9, the executive officer of Durgapur Faridpur Panchayat Samiti is also a party. No, I have debates respect for the objections taken, but they are parties. Now, my lord, kindly see, my lord, page 33 and page 40 would unequivocally go to show that, my lord, although today the petitioner is being made a ping pong, my lord, to go to shelve off the responsibility of the state, but page 33, nowhere it states, my lord, that the construction has been undertaken by the Panchayat Samiti or for the benefit of Panchayat Samiti or at the initiation of Panchayat Samiti. It is state, my lord, which has undertaken it, and the construction.
It is not correct submission.
The BDO has undertaken.
No, my lord. Panchayat Samiti itself.
Page 33 and page 40, the BDO has undertaken.
But it appears from the report, my lord, the order, my lord, the order sheet.
This is the
But
BDO's
Panchayat
letter.
Samiti is the separate identity, my lord, under the Panchayat Act. BDO is the ex officio executive
So
officer.
when the BDO has given the undertaking, he is responsible for this.
My lord, I have to take instruction on that point. Ex officio যেমন ADM G হচ্ছে জেলা পরিষদের তেমনি
Impromptu submissions won't help. This is very difficult.
So let him come back with instructions.
Kindly, my lord, kindly.
Please consider page 33 and 40 where the BDO has undertaken to return the land. So it
then
is
I have
his
to take instruction to that point.
It is his responsibility. The petitioners complain that their land has been utilized for the purpose of
Eco Park.
Construction of the
development of the Eco Park by the state authorities. Stop. The land has neither been acquired, comma, nor any compensation paid to the petitioners for the same. Stop. The paragraph, learned counsel for the petitioners refers to the order passed by the additional district magistrate within bracket land acquisition, comma, Paschim Bardhaman on 10th March 2022, wherein the concerned authority has admitted that the land in question belongs to the petitioner and has been utilized without any acquisition process. Stop. The authority has relegated the matter to the executive officer, comma, Durgapur - Faridpur Panchayat Samiti, Laudoha, LAUDOHA, comma, Paschim Bardhaman, to take suitable steps / decision. Stop. Letters issued by the block development officer, comma, Durgapur - Faridpur Development Block. Bracketed page, annexure P9 and P12 of the writ petition, bracket closed. Demonstrate that the authority has no objection to return the land to the petitioner. Stop. Paragraph, learned counsel for the state respondents seeks to take instructions in this regard. Paragraph, let the matter appear under the affidavit of service. Let the matter appear under the same heading after vacation.
Kindly make it before vacations, because this is, my lord, for the past 3 years, my lord, that time before this honorable court, my lord.
Very well. 11th May.
I'm grateful to my lord.
As a shoot
Deeply
the affidavit
obliged.
of service, and none appears for the
8 and 9.
8th and 9th respondents despite service.
I'm grateful. 11th.
11th May.
11th May.
11th May.
11th May. Deeply obliged.
Number 169.
I appear for the petitioner, my lord.
I appear-
Filing the affidavit of service. Lord, this is an application for restoration. It's an application for condonation of delay in filing the restoration of application.
There's a delay.
There is a delay of 90 days. Actually, what happened, my lord? My uncle was at deathbed, last stage of kidney failure, admitted to.
I cannot object it. Any restoration.
What about the writ petition? Can we deal with it today?
Let a date be fixed
Date may be fixed, no, another date. What's the suitable date?
before vacation.
Can one of 2023, 2 of 2023, action. The delay in affidavit of such delay in filing the restoration application being sufficiently explained, comma, delay is condoned. Paragraph. The petitioner has prayed for restoration of the writ petition by setting aside the order of dismissal passed on November 4, 2022. Paragraph, sufficient grounds being made out, the application is allowed. The order passed on November 4, 2022 is set aside. Paragraph, the writ petition is restored to its original file and number. Can 1 of 2023 and 2 of 2023 are accordingly disposed of. For WP, the order to me. Let the matter appear under the heading Group 7 motion on 7 June.
Good vacation.
You want to come back before vacation? Is it a short matter?
Motion stage, well, lots of
Motion stay very well. 12th May? On the 12th May. Yes, next.
If you are obliged.
Item number 170.
My lord, I am petitioner in person appearing in this matter through virtual mode, my lord. My lord, the supplementary affidavit is not ready. I am praying for 2 days' time to
Not ready.
affirm the same, my lord.
The petitioner seeks extension of time to use the supplementary affidavit as intended. Paragraph, let the matter appear under the same heading on 10th May.
My lord. Grateful, my lord.
Self-same cause of action already, my lord, matters, my lord, order passed by the coordinate bench. And again, this matter, when I drew your lordship's kind attention, then he said that I shall file supplementary affidavit.
Let him come back.
Number 171.
Petitioner,
171 and 172.
Mr. Mukherjee is appearing, yes.
My lord, 171, Mr. Nayak is for the state, my lord. He is only before courtroom number 25, my lord. Kindly make it, my lord, not.
On the last occasion also, my lord.
Last occasion, he wanted to take further instructions.
Instruct, not for
Back to
time.
the proposed amendment.
That amendment has not been carried out. Your lordship will find that was a draft.
You pointed out that it is a draft amendment.
Yes,
So
my
he
lord, this
wanted
is
to
under
take instructions.
subsection.
Come back next week. Next week?
It's a very short point is
Yes, it's a
informal.
very short point, yes.
And one of the another thing is that they have granted the permit in respect of the the additional vehicle they have allowed. They have granted the permit. They are
3rd May, next week, next Wednesday.
Month.
On prayer of the state respondents, the matter is adjourned. Let the matter appear under the same heading on 3rd May.
Much.
Number 172.
172 and 173 are the identical matter, my lord.
I am appearing, my lord.
One additional report has been filed in respect of one case. I have made ready exceptions.
Just now I got it, my lord. What additional report I do not.
You have not served an advance copy?
Just now I got it, my lord. I have
I
to go
could
through.
not get it affirmed as yet.
ও তাহলে এখন হবে কি?
Oh, as yet it's not affirmed.
Affirmed, ready. It has been made ready, but due to Eid Mubarak.
ও আরই বসে।
Come back sometime after.
Kindly fix this matter and particularly time, because it is a point of law important in this matter, my lord. Whether the PA.
After vacation.
No, my lord, after vacation, not fine.
আরে, এ,
But two vehicles, my lord, has been given idle, my lord, since
Yes,
2018. Since 2018, my lord, two vehicles remain idle.
Very well. 12th May. 12th May. On prayer of the petitioner, the matter is adjourned. Let the matter appear under the same heading on 12th May. In both the matters, 172 and 173.
I have served the advance copy of the exception.
173 same.
my lord.
Your Lordship, from the respondent, Your Lordship, the learned advocate is engaged in another court, so I'm praying for half an hour of Passover.
My lordship, on the last occasion, my lordship, last chance was given to file an affidavit in some form of a report, my lordship. My lordship, if the report is submitted, we can seek time to file a reply to that, my lordship, for 2 weeks, my lordship.
Yes, please make your submissions because last chance was granted on the earlier occasion.
My lordship, I am supplying the relevant documents to the.
Where is your affidavit, sir?
My lordship, I think.
Affidavit. Form of affidavit.
Yes. My lord, I seek 2 weeks time to file an exception to
You
this.
want to file an exception to this? Report in the form of affidavit submitted on behalf of the respondents is taken on record. Paragraph, learned counsel for the petitioner seeks to use an exception to the said affidavit.
My lordship.
Will you come back after vacation?
My lordship, interim order to be extended, my lordship.
So will you come back after vacation? You are enjoying an interim order.
My lord, you can come back
Yes.
after. Yes.
Let the matter appear under the same heading. On 9th June.
Grateful, my lord.
Paragraph, the interim order granted earlier is extended till 30th June or until further orders, comma, whichever.
Grateful, my lord.
Grateful.
Item number 175.
I'm appearing for the petitions. Look, this is relating to the e-rickshaw matter. My lord,
Who is appearing for the respondents?
my lord, we
My
have
lord, I am
served
appearing through virtual mode, my lord. I am.
Why are you in virtual mode, sir?
My lord, my health is not good. My lord, that's why. I deeply apologize, my lord.
Apology.
My lord, we have annexed a
He is not a party to the, you are not a party to the writ petition.
No, my lord, I have filed the intervention application. My lord, this case is different from other e-rickshaw matter.
But
There is an agreement between the petitioner and me, my lord, which is annexed with my
Where is your application?
my lord, I have filed the application on
Can 1 of 2023.
oh,
Let me just check, please.
my
It's not in the file.
file which February.
ওই স্যার 130 দেখুন order
Yeah, same.
My lord, it was filed on 15th of February.
Intervention কি বলছে পেয়েছে?
আজকে দিন মানে আমার ক্লায়েন্ট আজকে মানে আমার ক্লার্ক আজকে দিন দেয় অনলি ইন্টারভিউ এইটা দেখতে পাচ্ছি
28, 22, 22 এই অর্ডারটা চাইছেন এটা
I think the application has not come. Let me wait for another person.
My lord, it was filed on 15th of February. The next date was given on 17th of February. My lord.
My lord, if pleases, my lord, have a look at the copies that he has supplied to us. I find that it's just an intervening application. There is no prayer in that beyond the intervening application.
Yes, I know, because he wants to be added as a party. It should be on record actually, sir. So virtually, I could have taken a copy from him otherwise. I think it is there. That's it.
My lord, may I take your lordship's kind attention to page number 22 of my application?
So you have no objection to his being added as a party?
My lord,
I have no role to play with regard to my lord, whether his addition of my lord.
Yes, the petitioner has to
Between them.
respond. Are you raising any objection to this?
my lord, just a moment.
Or you want to go through the application and come back?
My lord, may I go through the complication? May I keep on next Monday or any subsequent date, my lord?
On prayer of the petitioner, the matter is come back on 8th May.
8th May.
Monday week.
My lord, on instruction, I say I don't have any objection. My lord, let me.
No objection? Very good.
let me-
So we can deal with the matter.
My lord, may I take your lordship to page number 22 of my application?
By consent of the petitioner.
Yes, yes.
Item number 176.
Let us hear the petitioner.
এটা হবে, এটা
Let us hear the petitioner first. Yes.
My lord, we say that the petitioner is engaged in the manufacturing of e-rickshaws. My lord, not taking my lord to the whole lot of documents and bunches. My lord, they kindly my lord comes to page 130 of my writ petition. My lord, page 130 of my writ petition.
Yes.
Yes. My lord, this is a similar order, my lord. My lord has been passed in another analogous writ petition, my lord.
Challenge the order on passed on 13 July and 28 September. What is that order?
My lord, may I?
Come to your prayer 8.
My lord, কোথায় আছে, কোন পেজে আছে ওটা?
You've mentioned a separate memo actually, a different memo.
As concerned, withdraw the memo dated the 28th, and memo dated special secretary government. My lord, these were the notifications by which the plying of e-rickshaws were stopped.
Yes, 28th September memo.
Yes, my lord, may I
I
just?
have not found this memo earlier in any of the writ petitions.
My lord,
It's 13 January and 13
Yes.
July. You've referred to 28th September memo.
এটা কোথায় আছে 28th September টা?
Prayer 8.
Yes, my lord, I've kindly gives me a moment, my lord. Well, I find an order of 28th September of 2022 at page 127 of the writ petition.
No, that's a different.
ওই মেমোটা কোথায় পাচ্ছ? আমিও তো পাচ্ছি না।
2 months from date of conversation. My lord, may I come back on 8th? May I come back on 8th, my lord?
I think there's a mistake.
My lord,
Rectify this.
this order, my lord, you must have the
Earlier.
advocate on record must have tried to mention the, my lord, order, but my lord, it had gone down.
Not even annexed.
Yes, my lord, I do not find that memo.
There's a memo at all.
But this is the order that might have he has wanted to challenge, my lord.
Gets confused. The
The
order
memo
was
is similar.
challenged before this court. It's a
Well, be-
repetition order.
Because my lord, yes, my lord, he cannot challenge it. But well, may I come back on
Our
8th?
probability he has missed the date.
My lord, he has missed the date, my lord.
So please
Lord, may I
come
come back on 8th? My lord, I was just fixing the matter on 8th.
on prayer of the petitioner, the matter is adjourned. Let the matter appear under the same heading on 8th.
So far, intervening application that can be allowed.
That is allowed. Huh.
Yes, ma'am.
That can be allowed by consent of the
Total
petitioner.
can be allowed. 1 of 23, the applicant / intervener seeks to be impleaded as a party respondent to the
So
petition.
এটা কোথাও নেই নাকি?
The application is allowed on consent of the petitioner. Paragraph, the applicant be added as respondent number 7 in the writ petition. Can such and such is disposed of. Title of the agenda.
My lord, I have not received the writ petition copy, my lord.
He was not addressed.
You have to give him a
I'll give him a copy, my lord.
So amended accordingly. The cost title of the writ petition be amended accordingly. Paragraph, the petitioner is directed to serve copy of the writ petition along with annexure thereto upon the added respondent and file affidavit of service on the adjourned date. Can such and such is disposed of. হবে না এখানে হবে the last line.
Memo তারাও তো লাস্টে
On prayer of
এজমা কেন
prayer of petition.
memo my lord, the affidavit of service were filed, we kept on the record.
Senior
In the writ petition. Writ
Yes,
petition,
ma'am.
affidavit of service. Writ petition. Aage affidavit of service.
Grateful.
Copy আছে নাকি না? কোনটা এই পরেরটা? Well, in this letter, I apply for the petitioner, my lord.
Yes.
This is petition relating to compassionate appointment.
There is a service.
Yes.
Compassionate appointment.
Compassionate
How
appointment.
can this court deal with it?
My lord,
No determination. This is a service matter.
transport, Calcutta State Transport Corporation.
Even then,
Even the next service.
চাকার ম্যাটার নয়, কি করা যাবে? সুতরাং অত
Not the
তাড়াতাড়ি
Motor Vehicles Act. Affidavit of service mean the matter is released.
হবে না এখানে। লবিতা ব্যানার্জি 25 হ্যাঁ
Liberty be given to mention the appropriate bench.
You have the liberty. Given order pass.
রিলিজ
Item number 177.
77, my lord, this is my application, my lord. But I have purchased a vehicle, my lord, from the
private
bank.
respondents.
I have received,
Here.
my lord, I have purchased a vehicle from a bank through e-auction, my lord. On the basis of a valid, my lord, award, my lord, passed in an arbitration proceedings, my lord. Thereafter, my lord, the bank issued no objection certificate for lien endorsement, my lord.
For the bank. Have you served? Where's your?
Yes. I have served, my lord.
Where is your affidavit?
No, my lord, I have basically no grievance against bank, my lord. My
But still-
transfer of name has been withheld by the RTO, my lord.
You have impeded the bank, so the bank needs to be served.
Yes, I have served, my
Where
lord.
is your affidavit of
Yes,
service?
I have handed over, my lord.
So, yes.
Now, my lord, thereafter, my lord, the bank issued, my lord, no objection certificate for lien endorsement. Thereafter, I applied for transfer of name, my lord. It was not transferred. I made representations before the RTO, my lord. Thereafter, I come up before your lordship before in this writ petition, my lord.
Still not been transferred.
No, my lord. That is my grievance. My lord, kindly see the my lord award, my lord, which has been passed on my favor, my lord. The award, my lord, which start at page, my lord. I have annexed is at page, my lord.
Award was not passed
favor, my lord.
Urgently.
In favor of bank, my lord. On the basis of that, my lord, I have purchased, my lord. Page 24, my lord. And thereafter, my lord, the lien endorsement, my lord, which is at page 35, annexure P5, my lord. 34, my lord. Page 34, annexure P5. And prior to that, my lord, annexure P4, my lord. That is the bank certificate, my lord. And the transfer which I have made, which is at page 32, annexure P3, my lord. The amount, my lord, as a highest bidding amount, my lord. Lord, against the award, there is no appeal, nothing, my lord. Even then, it has been withheld.
Yes, what does
My
the
lord.
state have to say?
My lord. Who is he? He is not the operator. He is not the owner of the permit. Nothing like that. He is only auction purchaser. Auction purchaser. Original owner of the vehicle is bank. Bank is the original owner. Under the provisions, my lord, owner must be bank after seizing the vehicle. The name of the owner first be incorporated in the registration certificate. Then his name be transferred. In that case, my state where he come before this court or state where come before the RTA cannot be RTA cannot entertain his application because he is nobody. He is only obtain a auction, purchase the auction.
And he has been issued a no objection certificate.
Yes, my lord, that no objection.
By the bank.
By the bank.
My lord, may I just,
Please allow him. to come.
The bank is
By the
appearing.
bank. Under the provision, my lord, he has no role to play unless bank incorporate his name in the RC book. Then he has the right to apply. He has right to issue no objection certificate. Bank only hypothecated bank can.
But I'm relying on a coordinated decision. Wherein that in similar circumstances, my lord.
Bank has asked for release of the vehicle in his favor.
My lord.
Bank has issued a no objection certificate in his favor.
My lord.
So to the effect
To
that the
that,
vehicle
to
is
that effect, my
transferred
lord,
to
there is provision, my lord. I cannot go beyond the provision of that. So Lord's will is section 51.
Section?
Section 51 of the Act. Section 5. Section 5, Lordship got it, my lord.
Yes.
Where the person whose name has been specified in the certificate of registration as the person with whom the registered owner has entered into the said agreement satisfies the registering authority that he has taken possession of the vehicle from the registered owner, owing to the default of the registered owner under the provisions of the said agreement, and the registered owner refuses to deliver the certificate of registration or as absconded, such authority may, after giving the registered owner an opportunity to make such representation as he may wish to make an him notice registered post acknowledgement to answer. This is the procedure. Here, my lord, a category says that a registered owner must be in the registered incorporated in the certificate of registration. Bank has to be incorporated in the registration certificate. Bank apply for registration. Otherwise, we cannot give stateway to him.
Owner means the possession, section 2, subsection 30. Whose possession? First, original owner, then bank. Bank took the possession. And registration certificate appears as hypothecated. Bank.
The bank is a necessary party.
The
actually.
bank will not appear.
You are appearing for the bank? Yes, what is your submission?
Lordship, I have already issued the no objection certificate. And I have also had.
Have you complied with the 51?
Lordship, I have to
Six.
take
May I
instruction.
just
I have
indicate
to
one
take
thing, my lord? I am for the owner who was the erstwhile owner, my lord. There is a suit pending against the bank, my lord. There is an order of injunction passed against the bank, restraining the bank from, my lord, dealing with the property. And it was passed on 30th of August. That is the date, my lord, when the bank has issued no objection. This is, my lord, the order of the court.
Lord,
And-
even if that is barred by res judicata, my lord.
That, my lord,
Absolutely
they are
barred by
appearing
res
in this,
judicata.
my lord. That's
By the suit code, not by this code.
My lord, absolutely res judicata, my lord. On that point, my lord, I am dealing, my lord, I am relying on a decision of this honorable court, my lord. Sections 11 of the CPC is squarely applicable, my lord.
This was till 30th September
my
2020.
lord, it has been.
Where is the last order?
It's last order. It has been extended, my lord, time to time. I can, my lord, submit.
That order.
My lord, we can
For
file
the
it.
purpose of suit, my lord, my lord, registrations cannot be withheld, my lord.
Because
The
my
suit between
case
the
is, my
parties,
lord, I am
my
the
lord.
lawful owner of the vehicle, my lord. How if it is
Lord,
transferred?
my lord,
Lordship, an award has been passed before this order, Lordship. Award has already been passed.
That is another aspect.
no appeal before against that award, my lord. The appeal still, the award still subsists, my lord.
Lordship.
And regarding the possessions, my lord, the possession has been taken over
This is
by
an
the
ex parte interim order.
My lord, now the bank is contesting the suit. As per my instruction, my lord, bank is contesting the suit before the court, my lord.
How is the suit maintainable at all after the award?
My lord, with the
It's a
suit is
service.
based on a, my lord, a fraudulent document, my lord, and
Yeah.
my lord, no, it's under, my lord, it's an arbitration award. It's not under SURFACE Act, my lord. It is not under SURFACE Act. So, my lord, section 34 of the SURFACE Act will not apply here, my lord.
Is dealing with this.
Yes, my lord. This is a declaratory suit, my lord, declaring, my lord, that I am the owner of the, my lord, lawful owner of the vehicle. My lord, see, it is does not cover under, my lord, the Securitization Act. So, section 34 will not apply here, my lord. They say, my lord, there is an award passed. Award was an ex parte award, my lord. We have filed a suit, my lord, that the entire payment has been made to the bank, and declaring that since the payment has been made, I am the owner. On that suit, my lord, this injunction order was passed, and here, my lord, the bank is appearing, my lord, and they're contesting the suit.
Lordship, the award has been passed in the year 2021 and they have
Will you
not
come back
filed.
with, will you
Lordship,
come back
I
with
will
a
come
report
back
in the form of
with
an
an
affidavit?
Lordship,
Will you come back with a report in the form of an affidavit?
Lordship, I will pray for an adjournment. I will take instruction from.
You'll
my
take
client.
instructions and
Lordship,
come back. And please consider the provisions of law also.
Lordship,
You have to be before the registering authority.
My lord, my lord.
After that is what learned counsel says. So please.
Lordship, I will
Lord,
take
even if
instruction.
this-
I will come.
My lord, one submission, my lord, for this, my business is hampering, my lord.
Presently, he has no locus.
Definitely I have a locus, my lord, on the basis of the judicial proceedings.
They
I
are
have purchased, my
purchasing
lord.
vehicles, you can.
Let them come back with their instructions. Affidavit of service. It is submitted on behalf of the petitioner that though he has purchased the vehicle in question through an auction from the
Hindustan Bank.
IndusInd Bank Limited, comma, being the fourth respondent herein, comma, the registering authority has not recorded his name as the owner of, as the registered owner of the vehicle. Stop. Paragraph, it is submitted on behalf of the private respondent that the entire dues of the bank has been cleared by the private respondent, and in a suit filed by the private respondent before the civil court, comma, an order of interim injunction has been granted in her favor, restraining Transfer of the vehicle.
Yes, my lord.
Restraining sale of the vehicle. SAL. Sale of the vehicle. Paragraph. The respondent bank seeks to take instructions in this regard. Please come back with these documents.
My lord,
also.
I shall come back, my lord. Only thing, my lord, it's not the entire dues, substantial dues. The amount
Oh,
is
you cleared the substantial dues code, entire dues. Entire burden is substantial dues. Let the matter appear under the same heading. 15th May. Grateful, Lordship.
Well,
Please come back
my
with
lord, may I
the,
take back, my lord, I shall.
the last orders.
Yes.
To show that it's still
My.
subsisting.
একটু আমার 23 আছে
কি বলছে
item number 178
এটা ফেরত দিন।
I am for the petitioner. This is that matter, Lordship, regarding e-rickshaw registration. But difficulty is this, Mr. Sinha is appearing, he requested me to take up the matter tomorrow since he is not available today in Kolkata.
Same matter, Mr. Sinha?
My lord.
Oh,
Same matter, my lord, but my lord, may kindly take it up on tomorrow, my lord, if it is possible, because I haven't received the copy of the writ petition.
You are a party to the
My lord.
Yes, Lordship. Respondent number 6. Respondent 6, my lord, kindly. Page 2.
Yes. Not today?
Lordship.
Grateful.
Tomorrow is Wednesday.
Yes, Lordship.
Grateful.
Not today.
item number 179
Yes, 179.
item number 179
Anyone for the petitioner? 179, anyone? None of this for the parties? Let the matter appear in the, under the same heading? Yes, in the monthly list of June 2023.
item number 180
Number the state.
My lord, I am intervening in this matter, my lord.
Where is your application?
My lord, today it has come to my knowledge that e-rickshaw matter has been filed, and I have not been made as a party in this writ petition, my lord. When I called my learned friend, Mr. Das, that kindly make me party, otherwise the order will be recalled. He said, if the court directs, I will make you party.
My lord, I can, my lord, make him party, my lord. Or with your, my lord. Yes, my lord. My lord, direct me and my lord. And my lord, this order will be the same order may be passed, my lord. I have annexed, my lord, page 263.
E-rickshaw cannot start without him.
My lord, now new patent is coming, hydrogen vehicle. It will also come before your lordship, the cases.
Well, 263,
Affidavit
my
of
lord.
service. তারপরে করুন, on prayer of the petitioners, liberty is granted to implead Mr. Kanishk, alias Gunjit Sinha. Please give your details.
Right.
Record
My
his
lord,
details.
I will send my friend my description.
Please give him the details of his, as respondent number 6 in the writ petition. Paragraph, the cost letter of the writ petition be amended accordingly.
My lord, I am right now sending my learned friend my details. My lord.
My lord, page 63, my lord, the same order. I am 263. I am seeking the same order.
The division bench order has to be included.
My lord, but I haven't received the writ petition copy, my lord.
263, my lord has passed this order. My lord, same order I am seeking, my lord. I am also the different kind of battery, my lord, not the fuel cell battery, my lord. That have.
He needs to go through the repetition. Come back, come.
Monday. Nothing remains, my lord, only, or maybe tomorrow.
On prayer of the added respondent, the matter is adjourned. The petitioner is directed to serve copy of the writ petition along with annexure thereto upon the added respondent and file affidavit of service on the adjourned date. Paragraph, the matter is adjourned. Prayer for-
Next,
That's on prayer of
Monday,
the
my
added-
lord, Monday, my
On prayer of the added respondent, the matter is adjourned. Let the matter appear under the same heading. Monday is monthly list day. Come back on 2nd May. Monday is monthly list. Day. 2nd May.
Grateful.
Wait.
Item number 181.
Well, in this matter, appearing on behalf of the petitioner, the matter relating to, my lord, the registration of e-rickshaw, on e-rickshaw, my lord, on the 11th April, a bunch of matter was disposed of.
Issues will never end.
Yes, ma'am.
Issues will never end.
It will be never, because so many, my lord, company and manufacturer. So, my lord, this order available, your lord.
Yes, Mr. Sinha.
My lord, I
Well, Mr.
haven't
Debra,
received
appearing on behalf of the-
petition copy, my lord. May kindly take it up on tomorrow, my lord. Both the matter 181, 182, my lord.
Yes, online, my junior already talked with Mr. Sinha online.
My lord, may kindly take it up
Assured
on
that he will be
tomorrow, my
available
lord.
online.
Kindly, my lord.
Record petition with judgment. That
No, my lord, but I haven't received the writ petition copy, my lord.
Online, ever talked? We have sent email.
But I haven't received, my lord. My lord, tomorrow I will physically appear
Same
before the
identical
court.
case that will be matter.
not today. Come back. Give it to me tomorrow. Not today.
No, only not today.
Is the day you will appear?
We wanted the back.
For next matter, I am
Same
matter, same.
Tomorrow, same. Mr. Sinha, appearing on behalf of the respondent number 6.
Not today.
Not today.
Yeah, not today.
Item number 183. Item number 183.
183.
Yes, 183. Anyone?
I am appearing, my lord, I think. Only
matter,
March
your
has
lordship.
applied for.
Further, my lord, the copy which has been served, my lord, date has been given to tomorrow. So only let it appear tomorrow or any other day. Because it's a simple question.
You are
He applied for, yes,
but
he,
it is petitioner.
my lord.
So both the parties
Yeah.
are there. What
Only this is
has
only a
applied
question
for
let's
online.
applied.
Only
It has not been yet
in the
considered
month of
direction.
March, in the month of March. Now February is going on.
Let it be kept. Let it be kept pending, my lord. Let it be. Well,
Pending.
even the service has been made that which has to be appeared on tomorrow. When I hand over tomorrow, because well, the form has been given with the date.
Online fill up and only in the month of March.
কবে ডেটটা কবে আছে মার্চে কবে?
Lordship can dispose of the matter, the next board we have.
Yes, my lord. Yes, my
meeting
lord.
matter can be disposed of.
Where is your application?
Our application is at page
The application copy ta de.
page 8. Annexure P1. Matlab page 8. Your lordship will find that 71 this application for permit in respect of a stage carriage permit to be regularly so used. This is the application. Now it mile.
Within?
Next board meeting.
As
This is a March, only March.
your lordship as
Within 2 months at least.
my lord.
So let it be within 2 months.
Within 2 months.
The innocuous prayer of the petitioner is for a direction upon the respondent to consider the application submitted by the petitioner for issuance of permit in respect of stage carriage
Route the wall for the route.
Submitted by the petitioner on what is the on 21st March 2023.
But the date is there. The route to
21st March 2023 is your application.
মাইলট ওয়ান ওরা তো ওই তো লিখেছিস কোথাও নাকি না সেটা তো
In respect of a stage
বাজকুল টু ভুবনেশ্বর
184 times. Paragraph, it is submitted on behalf of the respondents that who should be directed?
মানে the state transport authority মানে the respondent number
Respondent be directed to consider the application in accordance with law. Paragraph, in view of the above, the writ petition is disposed of directing the second respondent, second respondent to consider and dispose of the application submitted by the petitioner dated such and such within 2 months from the date of communication of this order. Paragraph, the decision taken order disposed of. A hearing is necessary for
মাইলট the all
upon affording reasonable opportunity of hearing to all the interested persons, including the petitioner, in accordance with law. Paragraph, the decision taken by the authority shall be communicated to the petitioner within a week thereof.
much of
Well, it is an interstate route if any vacancies are.
Accordance with law,
According to.
তো দেখেছে ওরা নাকি
court cannot insist on anything.
My deep loop.
এটা কোনটা
Next.
এটা কোনটা কোনটা এটা
This 184.
but in 180 also matter the it's a same is appearing as but the thing is that matlab they are also the in the presentation form but the date has been given tomorrow but the copy has been served day before yesterday so
I have not
6
yet
is time.
received any copy, only information from the.
but the same thing
I have also just.
only the same thing but
Mr. Singh is asking for consideration of his
I mean
application for.
in the meantime what
May I-
happened
may
my
I
lord?
tell Lordship,
Wait,
my lord? Lordship, kindly take it tomorrow. He says that during after filing, an intimation has been received that the already, my lord, they have, my lord, issued the notice to the petitioner that hearing would be held on কবে হবে?
28th of
So, my lord, let that copy, let him produce that copy tomorrow so that on the basis of that, my lord can dispose it of.
Very, not
Ma-
today.
এটা fixed আছে ওর hearing.
হ্যাঁ, তাহলে কাল এটা চিঠিটা দেখিয়ে দিন না।
হ্যাঁ
Not today. Not
কালকে চিঠিটা নিয়ে আগে।
আইডিয়া আছে
Idea
আছে তাহলে অর্ডার কি দরকার
না না ওটা দরকার আছে ওটা দরকার
I am paying for the petitioner, my lord.
In which matter?
Item number 949 of combined monthly list.
Lordship, I beg to appear on behalf of the respondents. I'm being led by learned Deputy Solicitor General in this matter, Lordship. Lordship, on the previous occasion, Lordship, learned Deputy Solicitor General has mentioned before your Lordship.
Yes,
I am for the private respondent in this matter. My lord, I have taken part in the tender process.
I think both of them are asking for time.
Lordship,
He's asking for time. What
no,
time?
I'm not praying for time, Lordship. On the previous occasion, Lordship, learned Deputy Solicitor General has mentioned before your Lordship is that in the affiliates of time, Lordship, the unsolicited proposal, which is the subject before in this writ petition, Lordship, has the respondents has duly considered and the factual positions, Lordship, and has decided not to proceed ahead with this unsolicited proposal and to in respect of terminating this tender process subject of the leave of your lordship's court since
Lordship, may I say
one order in respect of DG Raj Highway, that is WPA 23890, your lordship has directed respondents not to take any steps. So that one order which is standing in our way, lordship.
May I say one thing, my lord? In respect of the one tender which has been floated under the said petitioner, he is asking for time.
No, my lord, I am.
Absolutely, I was.
Actually, only one thing, my lord, to save the precious time, judicial time, my lord, I have taken part in the tender process, my lord. Now they are submitting that they are going to discharge the tender under the said policy. They may discharge the policy itself also. But my security deposit to the tune of rupees 1.30 crore is deposited with the railways. And I don't know, like, what is there in it in the instruction today. Actually, what I am submitting is subject to lordship's kind approval, my lord. If my learned friend file a report in the form of an affidavit, because it may be prejudicial to my interest, I will file an exception to that.
If it
And
is
there
prejudicial, if it is prejudicial, they always have the option of approaching the honorable court. My lord, the
Lordship, may I
railways,
have
the
not completed my
authority have
submission as
taken a
yet.
decision. I am here, my lord, to convey to your lordship the decision that we have undertaken, my lord.
Decision be on an affidavit.
My lord?
Did the decision be on an affidavit? Did it come on board?
Yes. But only one thing, my lord.
So that I can also use
My lord,
an exception to that.
My lord, it had fallen from your lordship during hearing of this matter that it is expected that during pendency, no steps will be taken. My lord, we are honoring, my lord, that particular observation, and that is exactly why, my lord.
Come on record.
My lord, it is there on record. My lord can take, my lord, we are before a court of record, my lord. I can circulate this if my lord directs me. And my lord can take this, my lord, on record, my lord.
I will be robbed with the opportunity of filing an exception to that in that case.
They can
Because
come
that may
back.
be
I can
prejudicial
circulate
to
if my
me.
lord directs.
That may be prejudicial to me.
That may not, my lord, the question of prejudice will not arise at all.
Give the others a copy of this. So
My
that
lord,
they are
kindly
aware.
direct. My lord, kindly direct me, my lord.
Only one thing, my lord, leave me be granted so that I can.
My lord,
if
today, my lord,
anything-
today, my lord, this submission is being made, my lord. My lord, when, my lord, this Khushbu Singh's matter is listed, my lord. So, my lord, we are, my lord, in Khushbu Singh's matter, my lord, that, my lord, we are communicating this. I understand, my lord, it is the petitioner, my lord, who will be having a say. But we understand what is happening, who had set up whom, but we are not going into that. We are not entering into that aspect,
one thing, my lord,
I mean, so far as DG Raj was concerned, now DG Raj's case was, now they said that no, I am not the technical partner, but I am the actual partner. So therefore, the offer letter should be issued in name of both of us. I am not the knowledge partner. That was the contention. Now, the actual person to whom the tender was to be awarded, which was their contention, DG Raj's contention. They are not here, my lord, I find. They are not submitting that. It is the person who says that no, despite being the knowledge partner, I will be treated as the partner and it has to be, the letter of acceptance has to be issued jointly. Now, my lord, he is now taking a point when, my lord, we say that, my lord, we have, my lord, in consideration
Probably,
of,
my lord, one thing.
in consideration of, my lord, the changed circumstances, there has been a decision, my lord, not to proceed with the unsolicited proposal any further and terminate the tender proceedings.
Only one
But
thing, my lord, what my
termination-
learned friend has not said.
Not the position to make a
Only,
submission.
only one thing, my lord.
He's asking for adjournment, so please come back.
But my lord kindly appreciates, my lord. My lord, the time of the honorable court is very valuable, my lord.
Come back.
And we, my lord, keep on, my lord, wasting your lordship's valuable time.
Without spending more time to.
No, no, my lord, this will, my lord, help in elimination of that particular, my lord, burden, my lord. This is
So that's why you.
nothing remains.
Today so that they can deal with it on the next day.
Very well. My lord, may kindly direct me to circulate.
Lordship, I will, if it is against me, my lord, because why?
You're filing it today?
Yes, yes.
Lordship, only one thing, my lord.
But these are the instructions, my lord. My lord, may kindly record, my lord, that I am filing the instruction and my lord directs me to circulate the instructions. I'll do that.
Only one thing, my lord. What my learned friend has not said is this: the persons who participated in the tender secured the railways earnest money jointly.
The private respondent.
Yes, madam. I will be suffering if this somehow. No, I'm not. Petitioner has challenged
My
the
learned
policy.
friend will get his turn, my lord, when his matter is heard. I understand.
But I am only prejudiced to
But
the
I'm just
extent.
asking the question to
I am only
myself whether
prejudiced
his
to the
case is there
extent.
in the list or not.
Submit your instruction.
Yes.
Yeah, I will be given an opportunity to file an exception, lordship, if it is against me.
How can you get an opportunity in this?
Well, probably they will forfeit my security deposit. They are not saying
If
so.
that is forfeited, his matter is there. Yes.
No, no, my writ petition is pending. There is a prohibited order, and in this writ application, there is no interim order.
Oh,
I'm
my
a
lord, my lord, on instructions, my officer is here. On instructions, on verbal instructions from my officer present here, my lord. My lord, may kindly record, my lord, the apprehension pertaining to forfeiture, my lord, is absolutely absurd, my lord. There will be no.
Kindly record that. That kindly record that.
Is there any scope for recording this at the moment?
Lordship, then kindly
Come back. let
Come,
him
I will
finish.
come back.
It is his
Yes, let his
petition.
case be, let his case be listed.
It is his writ petition and
He has,
unfortunately, he is not getting a chance.
নিজ ভূমে পরবাসী types.
Absolutely. The written instructions submitted on behalf of the state respondents is
No, I'm the railways.
by the railways. Railway authorities is taken on record. Paragraph on prayer of the petitioner, the matter is adjourned. Let the matter appear under the same heading on when will you come back? 16th May.
Anytime, my lord. I am always there at your lordship's disposal. my lord.
Put a file.
Copy the copy chain.
Direction না দিলে তো আমি কপি
Find it
দিতে
up.
পারবো না।
Yeah, that happened.
She directed them to serve a copy of the same to me.
Please instruction kept on record below. ওখানে copy of the said instructions be served upon the petitioner and the private respondent in course of this day.
My lord, instead of 16th, my lord, may it be, my lord, a bit ahead of that, my lord.
I have to take instruction, my lord.
Yes, the instructions, we are not
Private
in the month of
respondent.
May. We are on the 25th of
I have
April.
to take instruction.
we
My
should not oppose.
outstation client, my lord.
Should not oppose for the sake of opposing, my lord.
10th,
My lord, may kindly take it in the first week. May kindly take it in the first week of May.
they have 4 days.
This is a question, my lord, kindly appreciates, my lord, pertaining to the loss of revenue of the railways, my lord. My lord, that is why I would have not troubled your lordship otherwise. 8th May, grateful to your lordship. My lord, both the matters may be listed in that event, my lord.
This and the other matter is?
My lord, it's there in the instruction, my lord, it's written, my lord, it's WPA 23890 of 2022. That is DG Raj Highway Services, which is Mr. Roy's matter.
Probably
And-
that is a different
and
cause
this-
of action, my lord. Probably not.
Till now, he was submitting that, no, I will be agreed. Now he is saying that, no, that is on a different cause of action. My lord, may kindly take up both the matters together, my lord. That will help in, my lord. My lord, that will help in.
It's not in the list, so let us.
No, my lord, the instructions are, my lord, pertaining to both the matters. If my lord kindly takes
That
note, my lord.
cannot be. Instruction has to be with regard to.
No, no, because they are interconnected, my lord. This matter was directed to be guided by by your lordship's observation in the other matter.
That was the decision of the authority, not the court.
Yes.
No, of my lord.
Lordship, this matter,
Of my lord.
which is not at present,
My
lordship,
lord,
is a
let it
different
appear,
cause of action.
my lord, let it appear as, my lord, kindly appreciate, my lord, let it appear as to be mentioned both the matters on the 8th, my lord.
This way,
It will not take more than I understand. Mr. Mojumdar will be also here. Mr. Roy will also be considering the submissions. I understand it will not take more than 1 minute, my lord.
My lord, it cannot be
It will not
adjudicated,
take-
my lord.
it will not
Rival
take more than-
contentions are there.
950.
My lord,
I do not find the other matter.
Other matter is not, it's separate cause of action, my lord, completely a different matter.
my lord, kindly records that the other matter is on a separate cause of action because, my lord, on the next occasion also, I understand, my lord.
Already called the next one.
Very grateful.
Item number 950.
Lordship, I am for the writ petition, I mean. Lordship, this is a matter our lordship will remember.
Yes.
I am ready to hear, ready to argue this matter. This is a long
Lordship-
pending matter, petitioner is, has some interim order.
Yes,
That-
I
Just
know.
your lordship has-
Lordship, may I place
report is
this
ready,
case?
and
May I
exception
place
also
this
is
case?
ready.
This is my petition, my lord. Lordship, what has happened? Lordship, pursuant to one tender, my lord, petitioner was allotted or erecting 5 modular kitchen, lordship, in the form of Janahar at Asansol platform. My lord. Petitioner emerged as the highest bidder in respect of 5 modular stalls, and petitioner deposited the earnest money. Lordship, that happened in the year 2018. Now, lordship, 2018 gone by, first half, I have deposited the advance license fee for the first year, though the work would not commence because there was some issues, my lord. The issues were, my lord, non-availability of the space, no water connection, no electricity connection, nothing, no logistical supports were provided by the railways, my lord. And it has been acknowledged by the railways themselves in several communications thereafter. Actually, thereafter, my lord, I made several representations before the competent authority to provide me with the logistics so that I can at least commence at least the construction of those stalls. My lord, from the interdepartmental letters, which will appear at page on 34, 35, my lord, and also from page 36, it will be clear, my lord, that they are at fault. They could not provide the electricity and water connection bill, without which, my lord, no stalls can be erected. Now, my lord, all on a sudden, my lord, they came up with one letter which is impugned here, saying that the commencement of the business shall be taken into account from 20th of March 2020. Lordship will remember that particular month and year when there was a COVID declaration, there was a national lockdown, and also there were several advisories from the Ministry of External Home Departments, my lord, saying that except some essential businesses, all other businesses shall remain suspended till the relaxation is there. My lord, I could not construct those stalls in the year 2020. I approached before the competent authority for some connections from a private party. That was also not granted. However, under immense difficulties, my lord, I constructed those stalls and commenced my business from 21st of August 2021. Lordship will remember, I have stated that my license fee I have already submitted beforehand to them for the first year before the actual commencement of the business took place. That is in the year 18, I have annexed that receipt. It's here, annexed with the instant writ application. Now, my lord, the agreement is initially for the period of 5 years. My lord, my contention is this: as per the policy in vogue, my lord, as per the master license agreement, the date of commencement of the business shall be taken into account as the first year of the lease operation of the lease agreement.
The agreement says so.
Agreement says so, and also their policy says so. It is there. I will take your lordship to those. Now, my lord, I was aggrieved only to the extent that when the agreement says the date of commencement will be from the date of operation actually, or commencement of operation, then, my lord, the railways letter is saying that no, we will take into account 20th of March 2020 as the date of commencement. My lord, that is absolutely perverse and illegal and contrary to their policy. Challenging that, my lord, I preferred this writ application before this honorable court. Lordship was pleased to grant me an interim protection that railway administration will not take any coercive measure, because there was a threat of termination because I have not executed any lease agreement with them. Because the date was, lordship, which the date is the particular issue which requires to be adjudicated, my lord, from which date the particular lease agreement shall be counted, whether it will be from the 20th March 2020 or it will be from 21st of August 2021. Now, my lord, in the interim stage also, my lord, they were directed to file a report in the form of an affidavit. From the report, my lord, my contention, what I have stated here, that it should be from the date of commencement, lordship, that is proved. That has my point got substantiated. My lord, kindly come to page 5. What they have stated.
Yes.
Page 5 of their report.
Yes.
Lordship, kindly page 5, the petitioner, lordship, has from the middle paragraph. The petitioner has already informed by letter dated 1st of October 2020 that installation work was started in the first week of March 2020, but due to lockdown, everything is stopped, and as and when the condition will become normal and train restored, it will take 40 to 45 days for installation of all 5 catering stalls and start the business. Lordship, kindly, next few lines are very important. The Deputy Station Manager Commercial, Eastern Railway Asansol, vide his letter dated 25th of August 2021, informed Senior Divisional Commercial Manager, Eastern Railway Asansol, that the said 5 JMU stalls have commenced on and from 22nd of August 2021. So, my lord, it is their confession that the business commenced from 22nd of August 2021. What I have stated, or also they have also stated the same thing, and the policy also states the same thing. Now, my lord, kindly see who is responsible for the delay which occasioned for construction of the modular stalls. My lord, kindly come to Annexure R4, page 30. Their report.
Yes.
Actually, this is the interdepartmental letter which has been annexed here, my lord. Dated 5th of September 2019. Actually, I will not trouble your lordship with the entire letter, only from.
That is part of your petition also.
Probably this is not, my lord. This is something which they have, my lord, annexed it, and they have stated that delay is not attributable to the fault of mine. Delay is attributed to the fault on the part of the senior DCM. So you kindly see what they have written. Fourth paragraph, my lord. Fourth paragraph, my lord. Since may I read, my lord? Since the page 30, fourth paragraph. Since the railway has been emphasized on non-fare revenue by way of tendering out all types of commercial contracts, delay in commencement of the said catering stalls due to non-availability of water supply could cause negative trend in NFR, which is not at all desirable. You are therefore requested to personally intervene into the matter and to arrange to provide necessary water supply connectivity at all 5 stalls as stated above for commencement of stalls at the earliest. So, my lord, this proves that water connectivity, electric connectivity was essential for construction of the modular stalls, which they did not provide me. Had they provided me, my lord, it would have been constructed in 2019 itself. And I'm putting this question to myself, my lord. 2018, the letter of allotment was issued. I put in the first years of advance payment without commencement of the work itself that runs in several crores without operating. They are not saying that why you or your contract should not be counted from 2018. They are not saying why your contract should be counted from 2019. They are saying that your contract will be counted from 2020 to 20th of March, when there was no construction at all. Now, my lord, will another important letter which they have annexed, that will be at page 31. Next page. Lordship will kindly note the date. 25th of February 2020. Lordship, I will not trouble with Lordship with the entire letter, only from this third paragraph. Lordship, kindly see. This is an interdepartmental letter issued by the Senior Division Electrical Engineer, who on the basis of my application went there to give me the electricity connection. My lord, kindly see what happened there. In this juncture, it has been recalled for NFR for the commercial contract on which effect of the negative trend has been termed as not desirable. But this was totally confusing on your part, as it was been mentioned in your letter that work has been awarded by your department through OT. At the same time, second reminder has also been issued to this office for provision of electricity connection, despite the fact is that no site was made available for your tenderer. Instead, all arrangement has been done by electrical department, my lord. The person who went there to give me the electricity connection, he was not assisted with where the actual location of the stalls will be, because the location at that material point of time, my lord, was under their occupation, under their railway's own development work, over which subsequently the construction took place. So at that time, my lord, 24th of February 2020, there was no space allotted to me. So even if the no space is not there to me, then in that case, my lord, my respectful submission will be the date of commencement of business, that is 21st of August 2021, shall be taken into account as the date of starting the business in the lease agreement. I have not entered into any lease agreement with them, but I am paying all the freights in time. There is no default on my part. Now, my lord, kindly see from their own annexures. Kindly see, come to page 33, my lord.
Yes.
My lord, this is again an interdepartmental letter which they have annexed. It fortifies my case. In reference to the above, page 33, my lord. Yes. In reference to the above subject, this is to inform you that JMU stall installed, constructed in bus stand area has been provided water connection from PNU's toilet side on 22nd of August 2021. Lordship, kindly mark this date. For further use to run the stall, the date 22nd of August 2021 may be treated as connection date for reckoning water bill. So it fortifies my case further, because water bill is being taxed from this particular date, that date I commenced my business. Next page, my lord, page 34. This is also, lordship, fortifies my case further. Regarding electricity connections, page 34, my lord. In reference to the above subject, temporary electric connection has been provided to Nirmala Kumari, daughter of Ganeshwar Prasad Gupta, for provision on modular catering stalls on serial number Asansol South Side circulating area bus stand on 23rd of August 2021 with 4 number of electric energy meter, my lord. Kindly note, lordship, from the date I commenced my business, the subsequent dates, my lord, water connection, electricity connections were provided for the first time. So it further fortifies my case that the commencement of business should be taken into account from 21st of August 2021. And as per the policy, my lord, I will take your lordships to the policy. Lordship, kindly come to page 58 of the writ application. Letter of allotment. No, letter of allotment.
Yes.
29. 58, my lord.
Yes.
Lordship, clause 1.3, my lord, last.
Tenure of license.
Yes, tenure of license. The tenure of this license shall be for a period of 5 years, only from the date of commencement of the licensee, and there will be no extension and renewal. Commencement is from 21st of August 2021. Thereafter, my lord, master license agreement will appear, page 90. Page 90, clause 1.1. Page 91, my lord, page 1.1. Lordship has found, my lord. The parties agree that the scope of services shall be principally to operate, manage, and supply catering services on the GOME from the commencement date of operations. Railway will provide space for erecting the stall. The commencement date of licenses will be the date of commencement of sale after erection of stall, or 30 days from the date of receipt of communication informing provision of space from railway, whichever is earlier. So my respectful submission, my lord, the commencement date is 21st of August 2021. Their letters speak so. They have restored water, electricity, everything from that date itself. And also from their own letter, it will appear that there was no free space before that. Their own departments have complained against them that there is no free space which has been tendered to me so that proper connectivity can be provided. So as per this agreement, my master license agreement, and as per this policy, my lord, the lease agreement shall take effect from 2021 August and not 20th of March 2000. Lordship, on the date, there were a national lockdown and there were own circulars and advisories where everything was stopped because first wave and second wave came there afterwards, my lord. No one was allowed, trains were not operating on a regular basis. Everything was suspended. There was no space, no electricity, nothing. So this is my respectful submission. I have impugned one letter.
111.
That is at page 111.
They say 1st March 2020.
20. It is not possible, my lord, that from 20th of March, my lord, there was a lockdown. 2020, and they say this should be the date of commencement, knowing full well that they have not assisted me with all the logistics, which they are entitled to do it. This is my respectful submission, my lord, at present, my lord. Subject to what my learned friend says, I have a right of reply. Article 2.
May I submit, my lord?
Yes, my lord, only one aspect, my lord. I have, my lord, 92 also, page 92 of the writ petition, clause 2.1.
Yes, yes.
It says that pursuant to the scope of services to be provided by the licensee, the parties agree that the plan for commencement of operation shall be undertaken by the parties. It shall be the duty and exclusive obligation of the licensees to propose the plan for commencement of operations, which shall be subject to the approval by the railway. Any changes suggested by railway in the proposed plan shall also be duly implemented by the licensee prior to the commencement of operation. Howsoever, the license shall commence operation as laid down 1.1 of the licensing. They have allowed me to operate from 21st of August 2021. It is their property. They are the licensor, my lord. I am running this said stall at present. I am paying the freight. I am not a defaulter. My only contention, 2021 August should be reckoned as a date of commencement of operation, as evident from their document.
Learned friend, my lord, talking very good story, but their reality is quite different. My lord. Because, my lord, railway authority, my lord, railway is a public service, my lord. All the fund, my lord, this is a public fund, government fund. It is not just like a whole the Batasha. Learned petitioner is, my lord, very good businessman. She is running, my lord, good shop. Man. As far as my instruction, my lord, so she kindly come to, my lord, page 24, my lord.
Of the report?
Of reply, my lord. Reply.
Reply or report?
Report, right.
Page 20.
Annexure R2, my lord. That is allotment of, my lord, modular catering stall, number 1, Asansol South Side, circulating bus stand on reserve GMU, near bus stand. In considering your later tender mention under reference, the competent authority please to allot your modular catering stall on measurement of 100 square feet, that is 500 square feet, circulated area near bus stand reserve 5 years from the date of commencement of the work. That is later dated, my lord, 29/8/2008, my lord. That is the starting date, commencement. On terms and conditions stipulated in the draft agreement, signed as token acceptance subject to your fulfillment or following condition. That is the condition, my lord.
It's from the date of commencement of work.
Commencement, my lord, 2018, my lord, in the year. But, my lord, because of, my lord, after regarding, my lord, COVID period, my lord, railway authority not exempted all the requisite fees, my lord, not only Asansol, my lord, all over West Bengal, my lord, all over India, my lord. Where but stall is stipulated, my lord, they are exempted by the, my lord, railway board notification, my lord.
Exemption is not the issue in the petition.
Their issue, my lord, that not supplying the electricity and other things.
The date of commencement of work, that is the issue.
Yes, my lord.
So you have stated in the first paragraph that it will be taken to be.
Yes, 12/9/2018, my lord. That is the notice.
Of 5 years from the date of commencement of work.
Yes.
First paragraph of your notice.
Yes, ma'am.
Yes, carry on.
And in consideration of the award, my lord, the license shall be liable to pay annual license fee. The license fee will be fixed first 3 years, and in the 4th year, it will be enhanced by 10%.
No dispute. These are all. No
Just I show it, my lord. And next, my lord.
You have to primarily deal with the phrase from the date of commencement of work.
Yes, ma'am.
That is the issue.
Yes, ma'am. Iloshi kindly come to, my lord, para 10, my lord, page 9. What happened? The true fact, my lord.
Page 9 of the.
Page 9, para 10.
Of your report?
Yes.
Yes.
With reference to the statement made in paragraph 7 of the said petition, I deny, dispute all allegation contained thereon, save except the matter. I say that until the temporary structure of the stall is not created, provision of connectivity of water supply is not viable. Man. That is important. Man. Without, man, structure, my lord, how can electricity, my lord, viable? Man? Srimati Nirmalkar did not build any stall till October 2021. So, you know that if Malad building is not supposed to be constructed, how can be electricity Malad allotted by the railway authority Malad? On the last, on the next Malad, with reference to the statement made in paragraph 8, the said petition, I deny dispute that I say that as per work order dated 39/37/2019, Srimati Nirmakalli was advised to install modular stall. There is no need of water connection or construction of stall. That is also important, Mala. They are excusing some question of fact, Mala. Next paragraph, Mala, that is page 10, para 13, Mala. I said that there is no need of water electricity connection for installation of modular catering stall. Electric connection cannot be provided until temporary structure of modular catering stall fabricated by the party, considering safety point of view. On the next paragraph, my lord. My lord, I deny dispute the allegation and content. I say that for construction of modular catering stall, work order issued on 39/7/2019, and same was received by the petitioner on 31/7/2019. That is, my lord, just one day, my lord, railway authority take over this, my lord, stall, my lord. On the next page, my lord, chapter, in terms of para 3.5 of chapter 3 of section B, standard bid document, duly acknowledged by the bidder, railway will provide space for erecting the stall. The license shall be required to fabricate the modular stall as per specification of design material authorized the approved by the railway authority, and commerce business within 30 days. That is also important. Within 30 days of receipt of the communication informing provision space from railway. The commencement date of license will be date of erection of stall or 30 days from the date of receipt of the communication. That is, my lord, you'll have to kindly see that that is 31st July 2019. That is the allotment of date, my lord. And then within 30 days. That means, my lord, within my lord, August, date of August 29, 2019, my lord, that must be completed.
When did you provide the space for the stall?
That is, my lord, 31st July, my lord. July 2019, my lord. And COVID, my lord, taken into consideration, my lord, March 20, my lord.
No, when did you?
That is between, my lord, 7 months.
When did you provide the space? Where is the document?
Page 31st, the same was received petitioner 31st July 2017-19.
Where are you reading?
That is, my lord, page 10, para 15. Last line, my lord.
Work order was issued on 31st July.
Yes, my lord. Work order received, my lord.
Space provided.
Work
order is different, space is different.
Yes, my lord.
When was the space for the stall provided?
Space may be
These are all the petitioner's complaints that the space was not provided.
And they themselves were admitted that no space was made available to their engineer to give me the electricity supply.
But as far as electricity supply is concerned, that is quite different, my lord. But
space has to be provided by you, by the authority. When did you exactly provide the space?
That has been provided in time, my lord.
Document.
Yes, my lord. You also kindly come to page 29, my lord, of my report.
Page 29.
29, yes. Construction of modular stall, serial number Asansol, that is site circulating area, bus stand reserve. In continuation to this office earlier letter, even so, dated 29th of August 2018, since you have already deposited license fee of rupees 4,10,000. Why this? Security money 2,14,000. Why this? Dated 17 July 2019, issued by the Kotak Mahindra Bank. This is, you are hereby advised to construct modular stall on a measurement of 100, this is Asansol area near bus stand reserve view, that is GMU. That is letter dated 13th of July 2019. Memo number this, Malad. You should kindly see that bottom portion, Malad. 13th July 2019. So I think that is the, that after 1 month, Malad, it may be, Malad,
This
constructed.
one stall, serial number 1.
Serial number 1 to 5, Malad, quite similar. That is adjacent. That is yes. That is actually one stall. That is divided into 5 stall.
No.
As per my instruction, type the pasta stall.
There are 5 stalls, my lord.
Square feet divided into 5 stalls.
No, man.
This is 10.
Part stall.
Actually, there are one space that is adjacent to one stall to another stall. That I am talking, Malad. See, similar area, Malad. This is not another area. Right? As per my instruction, Malad,
Where is it stated that 5 stalls were given for?
5 stall, 100 square feet, Malad. You should kindly see that letter, Malad, 13th July 2019, Malad. That is the letter by the Malad Divisional Commissioner, Manager, Eastern Railway, Malad. That is quite latches on the part of petitioner, Malad. Because Lanet Page is saying that COVID period. COVID period starts, Malad, to March, after March 2020, Malad. That story is, Malad, that is July 2019, Malad. That is my instruction, Malad.
Plus only one aspect, my lord.
Please come to the next page, page 30.
Page 30.
These are all your communications,
Yes,
sir.
yes. May I read?
Yes. The relevant part. Please
Yes.
just go through it. You can find out. These are your communications, internal communications.
Yes.
So don't you think these are the admissions of the authorities? The next page also, the petitioner was not provided with any connection whatsoever for starting commencement of the stalls. And your agreement says that the agreement will commence on the date of commencement of operation of the stalls. Clear in the agreement?
That I am not denying, but
So
as
what remains?
far as negligence on the part of petitioner, Malad,
Where is the negligence on the part of petitioner?
because Malad,
And is there any negligence clause in your agreement? That if the petitioner fails to commence business?
that have.
Where is that clause?
The master license agreement, Malad, page 91, Malad.
Yes,
Onwards.
page 91. Please come to 1.1.
One point one I have gone through, but 2.1 article commencement of operation under the license. Pursuant to the scope
service to be provided by the licensee. The parties agreed that plan for the commencement of operation shall be undertaken by the parties. It shall be duty and exclusive obligation of the licensee to propose the plan for commencement of operation, which shall be subject to the approval of the railway. Any approval of the has already given. Any changes suggested by railway in the proposed plan shall be also duly implemented by the licensee prior to commencement of the operation. Howsoever, the licensee shall commence operation as laid down in Article 1.1 license agreement.
So it doesn't go in your favor at all.
I am not talking about favor, but some negligence on the part petitioner.
Where is the
Railway
negligence?
authority also has some negligence. Yeah.
The agreement specifically says that the commencement of date of license will be the date of commencement of sale after erection of stall.
Yes.
So erection of stall you have admitted it is on 22nd August 2021.
Yes.
So that should be the date of commencement of license according to your agreement. Yes. How do you respond to this?
I am only talking about their COVID situation, other excuse that has been their main excuse as far as this stall is concerned. Another part that cannot be, that is not
The only issue in the writ petition is the date of commencement of the agreement. No other issue. Negligence and all is not being dealt with at all. Fine. So the date it is admitted that the commencement of license, date of license will be the commencement of date of sale. Your agreement says so. How can you go beyond this? Well, let us continue on some other day. There is
Actually, only one
today.
aspect, my lord, subject to lordship, my interim order of protection is till 30th of April, my lord. Let it be extended. Let them come with a comprehensive opposition, my lord. They have
Opposition is not
required. Then, in lordship, kindly extend.
Can the case be developed after this?
Yes.
Yes.
তার একটা সুযোগ পাবে হারানোর জন্য
তোর fees হবে
Please take necessary instructions because your
Yes,
agreement is very clear. There are several documents which are admissions on you. So how can you come out of it? How do you overcome those documents?
give some direction, otherwise
What direction? No direction is
regarding this matters. Kindly, madam.
no direction. What direction can the court give?
Some direction, madam.
Steering-
that is much favor of me, madam, as far as official is concerned.
From this case, sir, I'm sorry.
Actually, interim order may be extended.
Yes. For learned counsels for the parties. So in that case, will you come back after vacation?
May I will
Because
come.
this is going on.
I am paying. Only thing, my lord, if it is from 2020, it will come to an end in 2020.
The license fees is pending, madam, as far as my instruction, madam.
There is no default. There is no default.
There is
on
no
the
default.
part.
It's pending, madam. Last.
No. I have paid. 2 days back, I have paid. The entire money I have paid.
That is not.
I can put it in
instructed by-
affidavit also.
I am instructed from 7 days before, madam. 2 days before.
2 days before I have paid. Then,
All right, all right.
Learned counsels for the parties.
Also,
comma,
kindly
the
record it. I have paid.
Kindly record this.
It is submitted on behalf of the petitioner that the entire license fees, what is it?
Entire license fee, as they have demanded, I have paid.
That the entire license fee
Lordship, I am telling the date.
as demanded by the railway authorities
Memo number to the other.
has been paid by the petitioner up to date.
On 21st of April 2023.
How much? How
On
much?
21st April
কত
2023.
rupees কত rupees টা বলে দাও।
Paragraph, let the matter appear under the same heading for further consideration
77 lakhs.
on
Deduction.
Second week of June, madam.
13th June.
Lordship, I have paid 77.
I'm not mentioning them. 13th June. Paragraph, the interim order granted earlier is extended till 30th June or until further orders, comma, whichever is ordered.
Lordship, you will grant me leave to file a supplementary affidavit to bring on record the payment I have made till date.
On prayer of the petitioner, liberty is granted to use a supplementary affidavit in this matter.
Also, my supplementary report also, if any.
Not
necessary.
I am paying.
No, report. On behalf of respondent, madam. Any report, madam.
You filed a comprehensive report, sir.
Wait.
Searching of the
He can't have, my lord, he cannot. He can't defeat.
Deeply obliged.
না, ঠিক আছে।